shop. We will take it. We'll take up the matter. It is listed today. You have filed PIL for grant of A4 license in scheduled areas in favor of scheduled tribe candidates. No, it is listed, mister. No, is it not listed? You don't know.
No, that is not his matter.
Not his matter. Some other cases.
There is a bill already listed before this court today.
For grant of license for A4 license. Liquor vendors and licensees fighting through public spirited individuals right now. Be ready to pay costs. We are putting you to notice. Yes.
Subject to your lordship.
So when do you want? Tomorrow? Fine. Be ready to pay costs. Yes, tomorrow.
My lord.
Fine. Think about it, how much of cost social worker should pay. Public spirited antecedent individual dealing with liquor license. Supposing if you would have filed a PIL saying that don't open a liquor outlet here, it is understandable. You are saying grant license. No. It can be a writ petition. That is understandable, but not a PIL. We'll ask you some questions tomorrow. Fine, be ready. We're just telling you to give our peace of mind. So you be ready. Then tomorrow don't seek time. Yes.
Subject to your lordship's kind.
So persons seeking reservation are so poor and so illiterate that they cannot approach this court. And that's why you want liquor license. Yes.
Yes, my lord. Matter pertaining to medical admissions, my lord, on the issue of local, non-local, my lord.
Tomorrow?
Urgency is that, my lord, results might be declared, my lord.
No, he said that it will not be declared. Mr. Prabhakar Rao has already made a statement in one of the matters.
One of the writ petition is numbered, my lord. Two I am filing today. Both may be listed tomorrow, my lord.
Tomorrow? We don't know what happens to the bunch today. We will list it along with that. Today it said.
Today, my lord, lunch motion.
There are, so get the matters.
Your lordship, lunch motion.
Your lordship, kind permission, your lordship.
It will be called today whenever it is called.
Mr. Ravi, that batch is there, no, today, that local, non-local.
Your lordship, fresh matters.
Two fresh.
You give him notice.
One is numbered, two fresh matters.
So give him copies.
Sure, my lord. In the mail.
Your lordship.
Yes.
Not seeking lunch motion, my lord. Petitioner's house is being auctioned. Petitioner's house is
Being auctioned.
E-auction. E-auction is
By
the Canara Bank.
then appeal DRT. Don't come here. Instant. We passed an order. You want an order? Give that right now. Yes. Mr. Registrar, get it listed. Order. Yes. In this writ petition preferred under Article 226 of the Constitution of India, the petitioner has called in question the validity of notice dated. Tell us.
The publication,
Has questioned the publication.
Publication here, petitioner filed suit against the defendant. He is in position, my lord.
No.
Performance is pending before the
Notice issued under which provision?
got any notice, my lord. Direct publication, he came to know yesterday.
Publication under which provision? SITI Act.
Yes, ma'am.
Has impugned the validity of the publication dated so and so issued under section 13(4) of the SITI Act 2002. Then Satyavati Tandon and 2021 judgment in view of aforesaid enunciation of law. The writ petition filed by the petitioner cannot be entertained. However, the petitioner is at liberty to take recourse to the remedy prescribed to him under section 17 of the Act. With the aforesaid liberty, petition stands disposed of.
One second. You are filing the writ petition now. Please meet the registrar with the SR number. He will get the bundle and.
No. And no. In case you have not filed, you will get a contempt notice from the court. Notice for contempt. Right? We have disposed of your writ appeal, making you available the certified copy. Proceed northwards. Instant justice, right? It can't be, justice can't be faster than this. Right? Yes.
Your lordship, with the kind permission, your lordship.
So get it, Mr. and
Yes,
Madam, sign it with, it should appear in the list disposed of. Yes.
Your Lordship, with kind permission, Your Lordship.
See, you are not in a classroom, right?
For my attention, sorry.
Not virtual mode also,
Sorry.
please.
Seeking lunch motion, Your Honor. The matter is urgency.
No,
Because
what-
regards to the PG admission into medical, Your Honor. Your
Tomorrow,
Lordship. I have already moved the WP. The WP was numbered, Your Honor.
tomorrow it will come up.
There is an urgency. Your Honor. Phase one admission is completed.
Second round of counseling notified? Not yet.
Not
Tomorrow? Yes,
My lord, my item is in the list.
it will be called. We don't want to continue this because many lawyers yesterday said that somebody has taken the adjournment in their absence and they were waiting. That's why we are not granting this. You bring both of them and jointly seek adjournment.
Item number 49 and 50.
1 minute. Both are there.
Yes, yes.
Oh, it will reach, Mr. But Praveen Kumar, it will reach.
After.
49.
49 and 50 minutes.
Who is there?
My lord, I'm appearing for the respondent. We have informed the petitioner they have
No,
no
no, that
objection.
petitioner is not there.
50.
Yes.
Serial number 40 and
You
50, I
should
am
be ready at the beginning, anything can happen. That's why you should be vigilant, right? They are
We are-
behind your back seeking adjournment. Yes.
Lordship, they informed us.
Inform.
Counter has to be filed.
Not the presence, learned counsel for respondents, pray for and granted. 4950. How much time?
3 weeks, your lordship.
3 weeks time. 3 weeks further time to enable them to file count.
Lordship, sir, my humble submission is item number 15, 17, 18, 19, your lordship.
It will be called.
Tobacco matters, your lordships.
Huh?
I have informed the GP for medical.
No. He is not here,
Yes,
GP.
my lord, they informed me. They
So-
informed me. my lord.
So this thing is both of you have to be present in case of out of turn mentioning.
Yes.
Which case?
14 to 19, my lord.
14 to 19.
Yes. This is with regard to, my lord,
Tobacco.
Tobacco
No. We asked you a question.
Yes,
Instead of answering, you are seeking out of turn this thing adjournment.
lordships, actually, my senior
No.
counsel is there.
No senior counsel. We said that this
it's a covered matter.
covered matter by division. We remember everything.
Yes, sir.
No, but why you don't have the confidence that even item number 14 would be called?
It will be cause.
Called, no?
Yes.
Then let it be called.
My lord.
Much of.
Nothing special
Sir,
about
lordships.
tobacco, right?
Much
You are just like a litigant covered by a judgment of this court. You have to tell us why we should not follow a division bench of this court. That's
My
Much
lord,
of.
my lord, item 51, my lord, I appear for the respondent.
Again.
Petitioner counsel is there.
And for the appellant.
51, my lord, your lordship.
Time for counter.
Your lordship may kindly grant us 3 weeks.
51 is hearing.
Yes, my lord. Counter
Commercial
not
appeal.
filed.
Commercial court appeal.
Counter not
Commercial
filed.
court appeal.
Coming for counter.
In appeal, there is no provision for counter.
My lord,
Which
petitioner.
provision, under which provision of High Court rules and orders, where is it that in a commercial appeal you file a counter, madam?
Respondent
You
counsel.
can file counter to play, or you file an application to receive documents on record which are not there, understandable. But which provision first tell us, and stop this practice. You are a young person, stop this practice of out of turn mentioning and seeking adjournment.
Obliged.
Stop. You first, it will be called 51. You tell us which provision in a commercial appeal counter can be filed.
Obliged. My lord,
We want you to
respondent
answer this.
counsel will come, my lord. Actually, she requested me to take adjournment. I'll
Don't-
inform her.
Don't act as proxy for adjournment
Obliged.
business. We don't want to, we have repeatedly told you,
Yes,
we don't want to begin our day with an adjournment.
obliged, my lord.
Yes.
My lord.
Covered, Mr. No,
170, my
nothing.
lord.
Wait,
170.
you want to withdraw?
No, my lord.
Eh?
It is actually.
Adjournment.
No, my lord, actually, in lunch motion, I'm paying for the 170. It is a registration matter, my lord. It is violating Article 14. equality of law.
170, it's, cases are up to 154.
170, my lord, sir.
170 in my list is not there.
That is a special bench, my that's 170. 230, special day.
Please tell him. See, Mr. Parallel communication is always very effective. Here, it's very difficult. He will not understand. The moment you will tell, because what is the perception that bench is hostile to us. It will speak always something against us. So they are not open. The moment you say horizontal thing is very smooth, because they perceive you as a friend. That if friend is saying something, so he will not. Correct. So how quickly he got it?
Yes, fine.
Yes. So Mr.
May it please.
Your case, right?
I am appearing for the appellant.
Acha. Oh, yes, yes.
I'm for R5.
Sorry. This is something different. We thought his case.
Yes.
Yes. Yes, please.
But the appellant before your lordship is
Joint Seat Allocation Authority, IIT Guwahati.
But the issue involved is admissions to IITs and NITs. The admissions to IITs and NITs are made through a common admission test.
Joint entrance exam.
JEE mains
and
JEE
JEE
advanced. JEE mains is for NIT and NIT plus admissions. So triple ITs and ISC are all those things. And then advanced is JEE advanced is for admissions to IITs.
Correct.
The writ appeal is filed against the common order passed by the learned single judge in 8 writ petitions. Item 1 and 2 are part of those 8
yes.
writ petitions. The issue involved is in all the 8 writ petitions, the petitioners are persons with disabilities. The contention of the petitioners before the learned single judge was that the business rules formulated for admissions to IITs and NITs require passing of 5 subjects by the candidates. But the petitioners claim
business rules.
Business rules are formulated by the competent authority for conducting the tests. This is going on for the past 10 years. Every year, it will be by rotation.
Yes.
This time it is IIT Guwahati and then
some other, in the next year somebody else.
Yes, the Ministry of Education constitutes the,
yes.
It is, in short, it is called JOSA.
So five subjects.
The subjects are
candidate is required to appear.
Required to pass.
That is math, physics, chemistry, and what else?
Mathematics, physics, chemistry, one language, and any other subject. It includes a second language also.
But somewhere in the rules it says, including the second language, you will be considered only as a language. So it will only be 4. In such situation, none from the Telangana or any other state board will be eligible, because state board have one, unless until you see you have this BMPC where they also have biology as one of the subject. Otherwise, nobody will be eligible. Otherwise, if you consider that.
No, so far as languages are concerned, they are treated as separate subjects. First language, second language, and third language.
No. So if a candidate, Mr. Physics, chemistry, and maths, and apart from which other one language?
One language.
Language is the regional language, or Hindi, English. It could be Telugu.
Yes, anything. It could be Hindi, English, Telugu, or any other
language. Like Kannada and this.
And a candidate can appear for 2 languages, which constitute 5.
Apart from this 4th language subject, 5th is any other subject means?
Any other subjects in some other states, so other subjects are also
like
there.
It can be political science also.
Yes. So,
for our understanding.
Yes, 5 subjects are mandatory under the business. I will take your lordships to those.
Fine. So what has happened?
The petitioners relying on Section 17 of the Rights of Persons with Disabilities Act, where an exemption is provided for the candidates with physical disabilities.
Yes, madam.
And
Act.
I have filed that is at page
68 to 10.
All right. So
page 17, you
rely on section 17 to say that they are exempted from the requirement of appearing in 2 subjects.
In second and third languages. Exemption is for second and third languages. So the petitioners say That is,
Eh,
this is
section-
mandatory.
1 minute. Section 17 provides that second and third language exemption.
Yes, madam.
Huh?
Yes.
What
Page,
is-
page 79 it is.
So we need to first understand what is second and third language.
Yes, but second
Is
and
it defined under the act?
no, my lord.
Second and third language.
It is simply said exemption from second and third language courses. It is at page 79, madam.
Section 17. 17.
17 starts at page 78,
Vocational trial.
17I. Third line, madam.
The which provision? I.
I, madam, 17I, third line. Exemption from second and third languages. madam. In the paper book, I have filed, madam.
Yes. To make suitable modifications in the curriculum. Business rules. Will not be considered, cannot be considered as some situation. All right, so your submission is that section 17 does not apply to
To
the facts of
competitive
the case.
examinations, madam.
Competitive exam.
It's only for qualifying in intermediate examination. Plus 12.
It applies only to what?
Intermediate examination, madam.
Inter-
Qualifying examination.
All right, and what else?
But
Second submission, we are hearing on admission, not
Yes. The-
deciding it finally.
the petitioners claim that this exemption is mandatory and they are unable to take the fifth subject. That they say, page 48, madam, in their petition, they say that if
No, no.
this is
Petitioners have passed physics, chemistry, maths, and one language
yes, madam.
exam, and they are saying that any other subject they can't appear.
They are forced not to take. That's what they say.
All right. Fine. Yes.
But in the examination minute, several candidates appeared. More than 80% of the candidates, minute, they appeared for 5 subjects in the same category. Physical persons with physical disability. I have given it page 61 of the paper book.
Yes.
More than 80% of the candidates, minute, they have chosen 5 subjects.
Wow. What else?
With persons with
Next point.
But the business rules, Milad, are applicable for all the candidates all over India.
Yes.
And having accepted the business rules, appeared for the examinations, Milad, they
When
cannot
was
know.
the examination held? When they appeared in the examination?
Milad, they appeared in the examination in April, Milad.
April 23. All right.
Now, Milad,
What date? Not relevant.
because of this, Milad, 2 categories are now created.
So what has learned single judge directed you to do?
Milad, the interim orders were first given, Milad, directing the admissions which are given to the candidates and cancelled. Milad, the interim orders were given to retain them. Subsequently, in the writ appeal also, in the writ petition also, there are judge set aside
These
the
persons
cancellation
have
order.
been admitted prosecuting studies.
Yes, Milad.
All right.
My only submission is, Milad,
Why
if
we are issuing
without,
notice?
without affecting their admissions, the admissions of the petitioners for the present, the issue about requirement of 5 subjects in the as required under the business rules,
We will
that may be
determine.
decided.
We will determine. Yes, definitely we'll decide. Heard on the question of admission, learned counsel for the appellant heard on the question of admission. This appeal has been preferred by Joint Seat Allocation Authority, IIT Guwahati, which had conducted the joint entrance examination in the year 2023.
Yes, ma'am.
Paragraph. Learned counsel for the
Publish. Remaining respondents, 1 and 5 are already served.
2 is also same.
No, Milord, I am taking Milord notice for the first respondent. Same.
He said first respondent.
Second
case, I am for the first.
second.
Second case. She is yet to call second. Same order, madam, second.
This is in respect of NIT's melody.
NIT.
JEE main.
JEE main and NIT, right? Admission to NIT instead of IIT, NIT. And same order. And then notice on behalf of R1 is accepted by Mr. So-and-so, office in the recollect his name. 2 to 4, you are seeking dispensation. You are seeking dispensation also in this case? No.
No. Suspension, I am seeking same
No,
order.
no. We are asking 2 and 3, your service of notice, you are seeking dispensation of service of notice, not.
Necessary, as not.
Not necessary.
So 2 and 3 submits not necessary, effect of dispensation service same shall be considered at the request and at the time of hearing of the appeal. And then same order, madam. This should come first, right? In that also, this part should come first.
Obligement.
IA is disposed of, right?
Yesterday's matter.
That's what we got confused by it. So he said, he was looking at us.
Written bill numbers I have written.
We have got the copy of the order for. Same
Common order.
common order, same order, right? Oh, Mr. P. Shri Harsha Reddy, learned counsel for the appellant. This is the order, madam. Fails and is hereby dismissed.
It may seek one intelligent minutes. The learned single judge has granted 2 months time to comply with the order. I request some
Yesterday we didn't grant. The order can't be different today.
much.
File an application. Delay condoned, madam. Delay condoned. IA is allowed item number 3 and then this order.
May it please your lordship.
Delay is also called. Or learned counsel for the appellant submits that the appellant is a necessary appellant was a necessary party to the writ petition filed by
Filed by the Wendy, my lord.
6 respondent
Alone.
respondent number 6.
Sixth respondent.
6 respondent.
Respondent number 6, wherein a learned single judge has issued a direction to register the sale deed executed in favor of respondent number 6. It is submitted by learned counsel for the appellant that appellant is the
Appellant is the owner,
owner of the property in question.
which was executed by the alleged sale.
No.
No.
Owner of the property in question by virtue of a sale deed.
No, my lord, he was assigned, he was an ex-serviceman, he was assigned this land.
The petitioner is the owner of the land as he was assigned the land in his capacity as ex-serviceman by the state government.
The state
He was
government.
assigned the land by the state government in the capacity in his capacity as ex-serviceman. Full stop. In view of a forced submission, issue notice.
My lord, one submission, my lord. There is a writ petition also that we filed simultaneously because the district register also, the appeal was filed without making me a party, challenging that order of the district register where appeal was filed by the Wendy without making me a party. We filed a writ petition. Your lordship may tag that writ petition now.
File an application. This on not done on an oral prayer. The other council says it is not concerned. We don't know
No,
whether we have jurisdiction.
that writ petition is filed by me.
Correct, but whether this court has
I'd
roster,
like to tag both the matter.
IA file this to tag. We
I
will.
filed an application.
Ah,
The difficulty is
Better,
because
better.
this was passed by a learned single judge. It cannot be set aside. That is it.
That's why, please.
Very
so I file an application for IA. We will pass an order. Simple.
Very well, very well.
Ah.
I'll-
Not in this matter, may I request, Lord, I'll file my IA, Lord, I've not noticed the amendment.
But
Huh?
I'll file an amendment to the prayer seeking to challenge the amendment also.
All right. Learn it. How much time?
Tomorrow, if you'll, I'll file it today, not if you'll just permit.
Batch is there today, Mr. Rao.
Batch is there today.
He has stood up to tell us batch is there and he will argue because his undertaking expires not to announce result. Whatever happens, we follow tomorrow. Learn it in your case. Learn it counsel for the petitioner prays for adjournment in order to enable him to move an application seeking amendment of the writ petition as prayed list on 19/8/23.
Correct. Obliged.
Please, your lordship.
Petitioner, there is an order CRPF not within
Yes, your.
8.
Yes, sir.
Oh, good, good. Great. So, yes, that's how you should be, right?
Page number 25 is a similar order.
We have already held.
195 to 37 of 23. Relevant portion is at page number 25.
No, we have passed an order, not a.
I apologize, your lordship. I am not aware.
CRPF BS is not concerned.
Yes. Yes, sir.
Mark the presence. Issue involved in this appeal. No, in this writ petition.
To go before the. Make a representation.
No.
Challenge to the. There is no challenge.
Obliged, your lordship. Thanks for immediate justice, your lordship.
What to do? There is no scope, right? We are bound by our own order, and we appreciate that you are so fair that you pointed out. That's what one should always do. It's not this thing.
This may be taken up.
Local candidate
Say 011.
It's a local will. This may be taken up along with item 21, lordship.
21, right?
21 to 27.
21.
21.
My lords. Challenging the action of the revenue officials, my lord, in protecting the government.
Representation with regard to encroachment, right?
Yes, my lords.
Huh?
That's right.
Your land has been encroached.
No, my lord, it's a private, public property, my lord. In spite of the representations made to the concerned authorities and the HMD also directed the
What do you say?
subordinate, my lord.
I take notice 1456. I
All of
appeal for
you
the
are
revenue
appearing
department.
on advance notice. All of you are appearing on advance notice, right?
Yes.
My lord, I appear for the revenue department, my lord, 4, 5, 6, 10, and 11. I'll get instructions, my lord. The land alleged is being a
You
government
appear
land.
for which respondent?
1, 4, 5, 6, 10, and 11.
1, 4.
5, 6,
Huh.
10, and 11.
What about others?
For respond number 9.
The standing council.
You have to tell, not that when court asks, right?
I have for the respondent.
This public interest litigation has been filed by the next date. If you don't come up with the compliance report stating that R10 and R12 and 13 and petitioner has been heard and this is the order which we have passed, right? then you are superseded. Don't tell 10 and 11 to file a suit and seek injunction. Huh? So don't give that idea that no, we will not oppose the prayer for injunction. You go to the court and we will inform the High Court that injunction is operating. I can't do anything. Don't do it. We all have been there, right? We have spent about 20 hours, 20 years that side. So we all know. You don't seem like, but notice on behalf of
Itself, their own wing wrote a letter asking them to take action within
Mr.
15 days.
Ah.
Nothing is done.
You have to Mr. GP Revenue.
Yes, my lord. I'll
To page 44. Grievances so and so. We have,
Yes.
it is pertinent to note that Hyderabad Metropolitan Development Authority by a communication dated 24/3/2023 directed the Municipal Commissioner Shamshabad Municipality to take an action on the complaint submitted by their term is coming to an end. Term is coming to an end. When it will come to an end? Tell Mr. We have got it. Why you are not taking action?
My lords, may I submit one? Under the guise of development of the property, my lord, they are going to create a third party interest. May I request for prohibition of the registrations, my lord? I sought a direction.
This now list pendants, everything you are safe. Anybody who purchases at his risk. That to a government property, right?
Oblige, my lord.
Mr. What are you doing? Mr. Revenue Council, GP for Revenue, your
I'll assure,
property, your
I'll assure,
property is being sold. Your person is the officer who will register the document.
But
He
I'll
should
assure
at
to
least
this
find
court,
out
I'll advise
that no
them.
conveyance is
This is already
executed in
public
respect
list.
of government property. He should save your property.
As per his submissions, it is already in the proprietary list, my lord. It can't be. Will take.
Oblige.
Lord, I may be permitted to withdraw.
Withdraw, learned. Learned counsel for the petitioner. After arguing to some extent seeks leave of this court to withdraw the writ petition, he is permitted to do so. Accordingly, the writ line below, accordingly, writ petition is dismissed as withdrawn. Yeah. Yes, Mr. Who is the petitioner?
Petition is a
Except from
scheduled tribe, my lords. Is a ST. He is the president for Tribal Reservation Board at Samiti. He is working for the.
No, he is a aggrieved person, right? He is a aggrieved person.
No, he is a file on behalf of the scheduled tribes, my lords, state, throughout the state.
No. See, Mr. There is a distinction we should clearly understand. Filing a rate petition in representative capacity and that is analogous to order 1, rule 8 sort of thing, or section 92, and public interest litigation are different concepts. So if you are saying that it is in a representative capacity,
Yes, my lord.
then it's a different thing. It's not a PIL, may not be PIL strictly. So it should not be treated as PIL, right? You are one of the aggrieved persons who is aggrieved by you want that 5% A4 liquor quota shops in non-scheduled area in favor of scheduled tribe. We will direct the registry to number as a writ petition. Right?
Okay, my lord.
Correct? Okay. Your grievance may be genuine, that we will examine. Yes. The petitioner is a petitioner is a person belonging to scheduled tribe. Full stop.
Please, your lordship. Lord, the respondents 1 and 2 have filed a suit for recovery of money against the respondent 3 to 5 before the commercial court, and also filed an application to order 38 rule 5 of CPC.
Who appears?
My lord, I am not a part. Yes.
You are
I'm for the petitioner, my lord.
petitioner. We have heard you on the last date.
Yes, my lord. My lord.
So the counsel for respondent has sought time on the ground that senior counsel, it has to be argued.
My lord, I mean, in fact, I mean, that representation was made on my behalf.
Okay.
I was not there on that day. Yes.
So what do we do?
My lord, the
Then what he says that yes, order is passed without notice to him.
Page 4.
Notice is issued,
The dependents of the suit are asking them to furnish picture.
but he is not a defendant in this suit.
He is mirrored in nature, third party attachment was sought. In a third party attachment.
No, but as per our impression, correctly subject, of course, to what you say, even a garnishee is required to notices. That's the contention made on the last date of hearing, that he being the garnishee, no notice need be issued, correct?
Correct.
This is what is recorded.
Kindly see mirror order 2146A mirror. Of CPC.
2146A. So let's then, yes, please, your submissions, we know facts, please submission in 2 minutes.
Yes, my lord, my contention is that
Number one, no notice.
I am not a party to the suit at all.
Not a party,
My lord,
no
with
notice.
With notice or without notice, my lord, my properties cannot
Yes.
be attached at all.
Ah.
My lord, even in the extreme case of lifting the corporate wheel also, my lord, that will be done only in the cases where some tax evasion is there, or my lord, some public interest warrants it. My lord, only in such cases, it requires, my lord, pleadings, and also, my lord, I mean, making the concerned company as a party, etc. My lord, such a thing is not there in this case. And order 21, my lord, I mean, it applies only for execution proceedings after the decree is passed.
Ah.
Yes.
So it decree is yet to be passed.
There is no decree, it's only the initial stage of the suit. Suit is pending and order 35 rule, 38 rule 5. Order 38 rule 5 also, whenever my lord the defendant is trying to my lord transfer his properties or my lord shift the properties from the purview of the jurisdiction of the court, my lord such a order is
Fine.
Permissible.
And in any case, it has been.
In any case, I'm not a defendant.
Not a defendant, and without hearing you, it has been passed.
Yes. Yes. That is my submission.
Even assuming it can be passed, it can't be passed without hearing you.
Without hearing, yes.
Nobody can be condemned unheard.
Unheard.
Yes. That's it. That's it, Mr.
No, I'm sorry.
That's it.
That's it.
Okay. Yes.
Only, yes.
Yes.
I'll take my lord's.
You appear for respondent number.
Only one respondent in the same party, my lord.
All right.
First respondent.
Yes.
Respondents are not necessary party.
Yes. You are appearing for respondent number 1. Yes. Yes, yes.
And my lord, plaintiff number 2 is respondent number, plaintiff number 1 is respondent number 2, my lord, is shown as not necessary party. Only one plaintiff has been shown as necessary party.
No, you are appearing for R1. Others have been served.
Not necessary parties.
Not necessary parties.
Because plaintiff number 2 is none else but the director of the plaintiff number 1.
So we can go ahead to decide, no, finally.
May I take my lord's matter to order 38 rule 7, but CBC.
Attachment before judgment.
Attachment before judgment. Order 38 rule 7, my lords, postulates mode of making attachment. Save as otherwise expressly provided, the attachment shall be made in the manner provided for the attachment of property.
1 minute, one. We are just. Yes. Yes, yes. Save as.
Save as otherwise expressly provided, the attachment shall be made in the manner provided for the attachment of the property in execution of a decree. Order 21 rule 46, my lord, provides attachment against third party charges. 2146A says, my lord, only after attachment notice has to be issued to garbage. May I read 46A, my lord? The court may, in case of debt other than debt secured by mortgage or a charge which has been attached under Rule 46, upon the application of the attaching creditor, issue notice to the garnish. It is only after the attachment prohibitory order being made against the garnishee, a notice would be issued to the garnishee under 46A. Now, my lord, in this case, lordship may kindly take a page 4, my lord, of the order, what has been challenged, my lord. What has been challenged before this court is, my lord, the show cause notice to furnish security. That is not even the order which has been passed.
Where is it? Which page?
My lord.
Red or 4.
This is the impugned order, impugned under challenge.
No, this is not the plastic. This is the protocol issue by which it says page 4, no order. This is the order under order 38. No, where is the order? Page 5. Upon hearing. Yes, we have seen the order.
This is the order. But this is not the order, but only a warrant asking him to furnish the security.
48 hours.
48 hours.
48 hours.
In the warrant of CPC, 48 hours notice has to be given to furnish security or show cause. He could have shown cause before the trial court as to why he should not furnish security, which he failed to do so. And my lord, thereafter, my lord, not be passed, my lord, prohibiting, my lord, the garnishing from alienating.
So how is he connected with the subject matter of the
My lord,
suit?
Lordship may kindly take up, my lord, the material papers filed by me, my lord, page 16, my lord, for a moment.
16.
Page 9, Lordship may kindly.
Madam,
my lord, the
one
material papers filed.
probably papers filed by
The running index, my lord, was filed on 5/7/2023, my lord.
5723.
23.
Clint,
May I take, my lords, to my lord, page 9 first, my lord.
pencil or ink. There are two numbers. One is 8 and 21.
9, my lord.
13 and 112.
I'm so sorry, my lord, 9 in the pen, my lord, 9. That's an MOU, my lord, that is document number,
Page 8,
page 9.
9.
9, 10.
So you realize it has two numbers, pencil and pen.
I'm so sorry.
Yes.
It's 9 to 13, my lord, the document MOU dated.
MOU
16th
dated.
December 2017, my lord.
MOU dated
16th December 2017, my lord.
yes.
This is, my lord, between, my lord, the dependent number 2 in the suit with, my lord, the direct shareholders, my lord, of Hindustan Concrete Blocks Limited. But I'll just read the preamble, my lord, at para 2, my lord, at page 10. Whereas the first party is desirous of acquiring 100% of equity shares, say.
Oh, 1 minute.
18,000
Give us 1 minute. See, 46A also applies. If there then that should mortgage which will be attached under the 46. So there so there has to be an attachment under 46. There is no attachment. So in this it will get no under the attachment. After the issue from the user. Code without hearing the same. There is submission and then they want to know trading building attached. So it is 46, 46 is true. But see, we have the gentleman to see this sort of requires. Yes, Goldman does not expect to respect the function. Mr. One thing, like we were just wondering that if your submission is accepted, anybody is illustration we are giving, just we are testing your submission, illustration. Mr. GP or some, not GP, he is the counsel who files a petition before in a civil suit saying that High Court is garnishing, it also court directs pay 1 crore within 48 hours, failing which building will be attached. So High Court is not heard. It's doesn't pay the bank guarantee and property. This High Court is attached at the instance of this person who is a plaintiff. One thing we are difficult to this thing, and the provision in any case does not expressly exclude principles of natural justice. So therefore, even if the provision does not say, we are well within our right to read the requirement of issuing of notice to any person, and it cannot be straight away an order of attachment of somebody's property can be passed. It could have been done by way of an ad interim measure by issuing notice. That is not done. It has been attached without hearing him.
Not yet attached. Notice was issued to furnish security.
No, 48 hours.
Follows thereafter, my lord, a prohibitory order has to come here. Because first notice was issued, my lord.
No, it doesn't say, what we are trying to understand. So whatever doubts we have, why we are putting it so that you can answer, right? Our doubts should not remain with us. So we should be fair to you.
I'll straight away.
So we are putting this thing, one thing, that order 4121 Rule 46A or none of the statutory provisions referred to you by you exclude the application of principles of natural justice that no notice is issued, he is not required to be heard before an order of attachment is passed. That is not the statutory provision, number one. Secondly, the court has not recorded any reasons that if it is not attached within 48 hours, the property itself or the appellant before us will disappear. So he is at flight risk, boarding the flight, something with property at 9:30 p.m. So court says that no, you can't board the flight. That is understandable without notice as an ad interim measure. There is no urgency. Like just a minute, no urgency in the sense, no imminent urgency of the categories we have pointed out. Like the property in 48 hours will not disappear. He has not recorded a satisfaction that he is trying to sell the property. His sale deed is due for execution pending registration of sale deed. Therefore, it is attached. Nothing of that sort. And he is not a party to the suit by way of an interpretative process. You are trying to incorporate, hold him liable by this document, that document. That can be done provided he is heard. So according to us, we will go into it, reserve the judgment if you want. But simple solution according to us is that let the court hear the parties. That will be less time consuming. Choice is yours. We decide.
Lordship may kindly see, my lord, to answer the question, my lord, that court has not recorded the reasons. Lordship may kindly see page 2 of the material papers filed by me.
No. So you say that the provision excludes principles of natural justice.
Lordship may see page 2, my lord, the order. Order passed. He has not filed the order. He only filed the warrant. Order I have filed it, my lord, at page 2.
Which pen or pencil?
It's page 2, my lord. Page 2.
Lighter weight. Yes. So you should be more cautious, madams, assisting senior counsel, right? Yes. Page 2.
Page 2, my lord. I'll just read para 2, my lord, from para 2 onwards. In support of the application, petitioner filed an affidavit containing that the above suit is filed for recovery of money of rupees on 18/6/2023 from the respondent jointly and separately, and contended that respondent number 2 issued letter of commitment on 14/9/2022 and agreed to pay a sum of rupees 7 crores 50 lakhs on or before 31/12/2022, and also agreed to pay a sum of rupees so and so due towards supply of stone metal aggregates to the petitioner on or before so and so. And further contended that in the letter of commitment, the respondent agreed to mortgage the property of Mrs. Hindustan Concrete Blocks Private Limited to the petitioners, and contended that the respondent.
So yes, we got it. So this order dated 21st June 23 is not challenged.
Not challenged. Only warrant has been challenged.
I am served only with the warrant because I am not a party. My lord, I cannot go before the court. My lord, nor can file a petition, my lord, to vacate this particular order of the court.
You can file an application for impleadment and seek vacation of stay. How can it be this? But how can we, in the absence of any challenge to this order?
One more thing, Your Lordship. Yes.
Please understand that subsequent is a ministerial sort of an act, so to say, not strictly ministerial, but a consequent action. Until you challenge to the you challenge the main order.
Yes.
This should have been your first submission, Mr.
So the warrant, the warrant Your Lordship has already seen. The main order also at page 3 also says defendant number 2 is directed to, my lord, the deposit furnished security for the amount, failing which, my lord, my property has been subjected to attachment. The D2 is, my lord, I mean, directed to furnish security, not me. And if he fails, my lord, my property is attached. Yes. In the matter notice, respondent is responsible, directing respondent number 2.
Correct. Yes, got it. Yes, Mr.
So
this is an order directing defendant number 2 in the suit to furnish pay.
Defendant number 2 is none other than one who has acquired 100% shares of this company, Hyderabad Concrete Blocks Limited. That is what the MOU which I was reading, and the letter of commitment which was referred to, my lord, by the commercial court.
Senior counsel, you will appreciate this. This by way of interpretative process, arguing here for 1 hour, you cannot demonstrate that he is actually liable, right? He has to be heard. What we are saying is the order says. No. We were asking you a question that what he said, that order, he is not a party to the suit, number 1, correct?
Correct.
Then there is a direction to defendant number 2 to furnish security. failing which the property will be attached. The order doesn't say whose property. Any person with this thing, ordinary prudence will think that it is D2's property which should be so attached. And in compliance of that order, somebody else's property is attached, thereby the cause of action accrues to him to challenge that warrant, that I am nobody, nothing.
He can challenge it before the trial court, he can come, my lord, he can get himself implemented. I am not on that ground, my lord, because I can satisfy. But here is the question, lordship may kindly see, my lord, he has given paper publications to sell the property.
And we will grant it the liberty to.
Yes,
All right, we have understood. So, Mr. What we propose to do is, subject to, still you can argue. What we propose to cut short the thing is that, as per our interpretation, subject to what you argue, this docket order directs defendant number 2 to furnish security to the tune of 10 crores within 48 hours, failing which scheduled property mentioned in the petition will be attached. So this scheduled property mentioned in the petition belongs to the appellant third party. So therefore, in the peculiar facts of the case, since the scheduled properties mentioned in the plaint does not belong to parties to the suit, therefore the court ought to have heard him before issuing in compliance of this order. Like anybody can then. This is what we are inclined to think. What subject to what you argue? Please, now we have told.
I just take my lord, to.
This is district. I will come and give the answer of that. Lighter vein. Yes. Brother is saying something.
It only reminds of a joke, Mr. Kishore, that if I pass 10th intermediate exam, I'll come and give third party's head for township.
Yes. Yes, please. Yes.
Why the suit was filed, my lord?
Yes.
Defendant number 2 had given an advertisement, my lord, in 3 daily newspapers to sell this property. Defendant number 2. That was considered, my lord, by the trial court, that newspaper advertisements will also filed, my lord, before the commercial court, wherein he was selling this property. And this is the only property left, wherein he agreed to mortgage his property to me in lieu of, my lord, my dues of rupees 10 crores and all. But that, my lord, para 5, my lord, I just read the order, my lord, wherein it is referred, my lord, to paper publications given by him to sell the property. And, my lord, what has to be meticulously followed, my lord, is order 38, rule 5 has to be followed.
No, we have, Mr. Rao. We have no manner of doubt that if defendant number 2, the court was fully justified in saying that if defendant number 2 fails to furnish security, his property should be attached. No problem. But somebody else's property is being attached who is not a party to the suit. That's the problem.
I'll make a submission. But for that reason, my lord, I was reading the MOU, wherein he has acquired 100% shares of this Hindustan Concrete Private Limited.
Then you should have been all fair. This thing you should have implemented him as party to the suit, so he is bound by the result of the suit.
But because, my lord, letter of commitment at page 19, lordship may kindly see, my lord, issued by defendant number 2, wherein he agreed to mortgage this property. Page 19, lordship may kindly see, my lord, with the document number he has mentioned.
So what you say under MOU dated?
There are 3. There is a letter of
commitment. What was the date of institution of the suit? Is it after institution? Is it after institution of the suit MOU by which D2 transferred?
Much prior.
No, D2 according to you transferred 100% share in favor of the appellant.
D2 acquired the shares, my lord, of Hindustan Concrete Private Limited, 100% shares. D2, for the purpose of acquiring 100% shares, borrowed money from me, saying that he will transfer 25%.
So how he is saying that the property, it doesn't belong to him? You didn't argue that the property doesn't belong to him.
Well, it belongs to, my lord, Hindustan Concrete Blocks Private Limited,
whatever.
of which he has acquired 100% shares.
No, is it your case that the property in question doesn't belong to appellant?
But it belongs to Hindustan Concrete Blocks.
No,
Limited.
no.
That's what I mentioned in the application also, that it belongs. Lordship, may kindly see letter of commitment at page 19 for a moment, my lord. Letter of commitment, my lord, given by DG,
Hindustan Concrete Blocks is the petitioner before us who
Yes,
is not a party.
who is not a party.
That you are saying that it belongs to him.
Lordship,
It
may kindly
belongs to it.
see, my lord, page 19, my lord, letter of commitment.
Lifting corporate, we cannot lift after order is passed. It should be all right. We cannot lift the corporate wheel after the person has suffered an order without hearing him.
That is what is my case, my lord, before the commercial.
We perhaps. You should have, that's what I said, that to avoid multiplicity, you should have been pleaded on this. Yeah. So when was the suit filed? When was the MOU executed? Chronology of events, Mr. Senior.
2017.
MOU.
is, my lord,
According to this document, 2017.
MOU
15th
dated.
October 2018, my lord. MOU with me.
No, not with you. Under which? Acha. MO with you for taking loan. What?
For taking the amounts, my lord, to acquire the shares of Hindustan Concrete Private Limited.
No, this respond number 2 has taken loan from you and not paid.
Not paid.
That's why suit for recovery, right?
For recovery. Yes.
So under MOU dated 15/10/1998,
2018.
18, you have advanced loan to defendant number 2, correct?
Even otherwise, my lord, there are supplies also made.
Advanced loan to D2. All right, then what happened then? D2 transferred the share to whom? When him?
My lord, Lordship, may kindly see page 15, my lord, what he says, my lord. Whereas the first party is the shareholder of Mrs. Hindustan Concrete Blocks Private Limited Incorporated, India, with 99.99% shareholding. Whereas the second
Which
party
page?
is page 15, my lord.
15. This is your plaint, right?
My pleadings, my lord.
Pleadings.
My material paper,
MOU.
index, page 15.
MOU is 15/10/1998.
2018, my lord.
18, sorry.
There are two MOUs, my lord. One MOU, first MOU starts at page 9. That is a 16th December 2017. The second MOU is with me 15th October 2018. May I take my lord's note at page 15 of the MOU of my material paper.
And second is? Mr. Senior Counsel, we request all time and again to give us a synopsis, right? There is absolutely no justification for spending half an hour time on 23 and keep 2005 people waiting.
Yes.
It weighs our conscience. All this is like he's narrating so and so, first MOU, second. Why should you not do it if you are in a hurry? Give. It could have been less than 5 minutes. All chronology. We are just lifting corporate wheel in the copy.
With respect to Lordship,
Now we have spent so much of time, 10 minutes more. Finish you. So MOU 15/10/18, second MOU.
Page 15, Lordship, may kindly.
No, date.
15th October 2018, my lord.
That was the first one.
Second one. The first one is, my lord, with my lord, defendant number 2 and my lord, the shareholders of the company to acquire 100% shares.
16th October 2017. 16th, first MOU. 16th October 2017. Second MOU is 15th October 2018. Between the second person, respondent number 1 and 2. So correct, right? 2 MOU between R1 and R2 on 16/10, 15/10. We did not pay the amount, suit was filed. When this is the letter of commitment.
This letter of commitment doesn't have a date. Letter of commitment doesn't have a date.
So when was the suit filed?
This time 2022.
Where do we get that? There is
Please, my lord, see under the signature of the witnesses
witnesses signature. We have.
and also on the signature of the defendant.
Letter of commitment by defendant number 2 to read.
Mortgage this property, my lord, giving the document number 2467 of 2013 at page 20.
To mortgage.
Original document.
All right, fine.
Of the factory land.
Fine. So when was the suit filed?
19/6/2023, my lord.
19/6/23. Then where have you described have you said in the plaint, Mister, that this property belongs to the appellant?
No, no. Had that been done, lower court would not have passed this order, my lord.
No. So,
They did not say that, my lord, this property belongs to.
no, so then under which MOU defendant number 2 transferred this property to appellant here, petitioner here? You said 100% share owned by.
So the property, my lord, of Pakistan, my lord,
Concrete
company,
blocks.
Concrete Private Limited.
Right from 2013, my lord.
Right, but the property was purchased under the registered sale deed by the company, my lord, of 4467 of
No,
2013.
property purchased by petitioner.
No, Hindustan Concrete, British.
Petitioner.
Under document number 4467 of 2013. 2013, man.
Registered sale deed.
Yes, that's fine, my.
Registered sale deed dated.
10/7/2013. 10/7/2013.
So this sale deed has been set aside or they have sold. So when they have sold the property to defendant number 2?
Share transfers were done, my lord.
2.
100% shares of this company was acquired by defendant number 2. Under the first MOU.
All right.
Thereafter, my lord, after the acquisition of the proper shares, my lord, he agreed to transfer 25% shares to me under the MOU, my lord, actually the entire to me.
Second MOU.
15/10/2018.
Second MOU, had defendant number 2 agreed to transfer
55% of shares to me.
of this appellant,
Company.
petitioner.
And on 14/9/2022, he gave a letter of commitment to mortgage this property to me in lieu of my deed of 10 notes.
And 14/10
14/9/2022.
mortgaged. Yes, letter of commitment.
Mortgage.
Got it.
And in the plain, my lord, I have categorically pleaded, my lord, this property belongs to Hindustan Concrete Private Limited at para 12.
Para 12 of
Plain, my lord, at page 30. The plaintiff states that by letter of commitment, the defendant agreed to mortgage the property of Hindustan Concrete Blocks rented to the plaintiff, which property is covered by salient data bearing document number so and so dated 10/7/2013.
especially on the back. Belonging to the.
And not
All right, we have got it.
page 22 and 73, my lord, which are the summons issued to different number which are filed before this court. And my lord, one more submission, my lord, that garnish, my lord, third party attachment is sought against the third party. Third party will not be made a party in the suit, my lord. I have also relied upon the judgment of 2023 3 of the division bench of our High Court, my lord.
No notice to third party.
He cannot be a party also, my lord. That is page 80, my lord, of my running index, my lord. They have already filed. Like that. Page 80, he need not be a party. And then the full bench judgment of the Kerala High Court varies where, my lord.
Which is our division bench?
2023 380, page 301.
2023
3A, page
AD.
301.
AND, page 301. Andhra legal division. It's already filed at page 81.
ALD, page
301. It's already there, my lord.
already there. Where?
Page 80, my lord. Para 19, lordship may kindly see. The relevant para is page 89, my lord.
Para
19, my lord. At page 89. I'll skip that entire para 19.
Now, this is submission.
Last 3 lines of that paragraph, referring at page para 19. Therefore, in case on hand, the plaintiff could seek attachment of the properties of the first defendant lying with the government of Karnataka, even without making it as a party to the suit.
No, this, Mr. Counsel, this appears to be submission, right, of senior counsel for
Therefore,
revision petitioner,
Yes, submission.
the finding-
wherein it is as
Para 54, my lord, they-
place reliance on judgment of Andhra Pradesh High Court in so and so 2 paragraphs. Therefore, in case on hand, plaintiff could seek. This is not the finding, submission of petitioner.
Then what is it?
That's it. Thank you.
What is the full page judgment also, my lord, where it's
Which full bench? Which full bench? judge?
73 Kerala, my lord.
Garnishing need not be. Garnishing need not be a party.
It's not on garnishing, my lord. It says, my lord, third party can go to the trial court and seek, my lord, raising of attachment. Under our 38 rule at time.
Ah.
It cannot come, my lord. Before
I mean,
attachment, they cannot.
read petition under Article 227. No, does it say so?
No, no.
Interesting thing.
It doesn't-
It's a constitutional right, to approach under Article 227. You may say that because an alternative remedy, we should not interfere, that's a different thing. But he can't approach, no court can say that nobody can file a petition under Article 227. 73 Kerala, AIR,
Page 1, my lord.
page one, which page 1? Which page?
Page 10.
104.
Page 104, my lord.
Ah, yes. Attachment of property. All right. Anything else?
Yes, sir.
Thank you.
There's one judgment of learned.
Thank you. Mr. Senior
Yes,
Counsel,
yes.
henceforth, we will not hear your case, any case in motion hearing like this. Please give us synopsis. If you want us to, we understand commercial disputes, they need to be heard. But please, it weighs on our conscience that 2005 people waiting and 23 commercial appeal, half an hour, we are noting down and deciding it.
May I
Please,
just
now
make my,
next this thing, please assist.
may I just make my brief submission in reply to my lord, the submissions of the senior counsel.
1 minute.
Yes, 1 minute. Yes.
Yes.
My lord, insofar as Order 38, Rule 7, quoted by learned senior counsel, my lord, that says only the manner of, my lord, executing the attachment. That is only ministerial act of the court, my lord, that not the judicial act of the court. That is my submission. Second thing is about this, my lord, memorandum of understandings between the plaintiffs and the D2 and also letter of commitment, etc., given by him. What the D2 will, my lord, say about those things, etc., I do not know today. My lord, they are of the year 2018. My lord, those are binding only between D2 and this plaintiff, but not on me. Third thing is, my lord, I am a juristic body by myself. My lord, I own this property. My lord, this property which is made subject matter of attachment, my lord, sale is there before lordship. I filed in the material papers, 2013 sale deed. It's exclusively belongs to the petitioner before lordship. My lord, even if D2 has acquired, my lord, 99% shares in this petitioner company, still, my lord, company as a juristic person, my lord, remains as it is. It will own the property and it will continue to own the property. My lord, insofar as this garnishee thing is concerned, so many judgments will have senior counsel placed before the honorable court. My lord, garnishee, your lordship knows very well. If the defendants, my lord, have to get some amount from some XYZ third parties to the suit, then my lord, plaintiff will be seeking the court to issue a garnishee note to order to those third parties so that they will stop paying to the defendants. They will stop, my lord, pay directly to the plaintiff himself. That is the.
But do it like 1 pin, it would have saved plenty of time. Within 5 minutes, both of you would have been able to conclude, and we are not required to write. All this is what you have said, which MOU, what date. These two people standing behind you should work more hard. In this petition, mark their presence with consent of the parties heard finally in this petitioner.
Yes, but now the
Correct.
LMI, yes. Now at this stage,
No. So can you consider setting up of this thing? Your what? Petrol outlet?
Yes.
LPG. Yes, an alternate location which is adjacent to it. It's not contesting the case on merits, right? You seek instructions.
Very well.
This is adjacent, madam.
Yes, your lordships. It is immediately in the same jurisdiction and adjacent, your lordships.
Adjacent and same jurisdiction are different things.
Adjacent, your lordships. It's in the
Right,
same
so
vicinity.
many this thing areas may be under jurisdiction of Gachi Bauli police station. So that doesn't mean adjacent.
Your lordships, my instructing counsel has instructed me it is in the same vicinity, your lordship.
Yes, but also there's another issue, my lord. There are third party rights.
No, you, this thing, see, mister, consider this of an amicable settlement. If not possible, we will adjudicate.
Like only one submission, not judges may consider, because
No, will you consider, I mean, seek instructions. We are asking you to seek
I
instructions.
certainly will, my lord. I have to bow down to your lordship's instruction. I just want to bring to light what is the situation, not permit me one submission alone. There is an LOI that has already been issued to another party.
Oh, madam, what?
Your lordships, about that LOI, since your lordships, the merits, the LOI has been issued to another party pursuant to this cancellation, your lordships. However, I have
Implemented.
given the reply also, have implemented him. He's not answered. He's not answered.
Four is there.
Yes, your lordships, he's not answered it. Proof of service also has been
Just a minute.
filed and absolutely no construction has taken place.
1 minute. LOI issued to respond number 4 when?
In 2021, my lord.
What happened? He is still not commissioned the LPG.
It had to be a conversion of land from agricultural to
It's pending, right?
That, my lord,
So despite notice, he is not coming forward to oppose the condonation delay. What, madam?
And in the
Condone delay at least.
delay is at 78 days, your lordships. And in that, I've also included photographs, your lordship.
Yes, yes. So he has not commissioned this thing, not.
No, your lordships, not
appearing.
until this day.
Despite service, madam, not appearing.
Yes. He's not,
Get
he's
the
clearly not
instructions,
interested.
certainly.
But probably you cannot decide in this way, this matter, because you have already issued a LOI to third person.
And in my counter to the IA,
No, what happened that third person, what did he do?
I have answered in my counter, my lord.
Huh?
I have said,
Started the go down and.
Down and.
No, your lord.
Like,
my lord, in my counter to the IA, I have given the current status of the LOI.
You tell us, no, you are here
Yes, my lord,
not to
permissions.
tell us that read my counter.
I'm certainly. My lord, permissions have been applied. Now, my lord, it is.
Permission under what act?
My lord, he has to get safety permission. Lordship is well aware, my lord, various permissions from the department.
Explosives act.
Yes, my lord.
Then say so.
No, other than that, even from the police.
No, you are saying that land has not been diverted,
Conversion, lord, for conversion.
converted. It's an agricultural land
That conversion has taken place, but my instructions are the conversion has taken place.
taking place since 2021.
Yes, but they,
2 years conversion doesn't take place.
my
You
lord,
ask your colleague GP for revenue.
I'm aware.
Mr. Revenue, you take 2 years to convert the land. The LPG, this thing is not being commissioned and 2 years. Officer, no, you are not GP revenue. We thought
Medical and health.
medical. Oh,
If I may submit for a second, your lordships, in the counter, council has already stated the NALA permission has been granted on 24/3/2022. At paragraph 8 of the counter, at paragraph 9, 8 and 9, your lordships, all the aspects of conversion, etc. of the alleged has been completed, and they have stated under oath that the go down construction is in progress without even checking whether the go down construction is actually in progress. I have
1 minute, madam, 1 minute. We are in your favor. So you should
Yes,
be
yes, yes.
comfortable, right?
Yes.
Huh? If we start asking questions to you, you will be uncomfortable.
yes,
When I was a counsel that side and the moment court said anything, ask the other side, I used to sit down. That's what ideally speaking you should do until unless
yes.
asked upon to speak. Mr. One query you have to answer, which is not addressed. This is the point. Letter of intent issued to the petitioner was conditional and subject to outcome of WP 40719 of 17, right?
Yes,
Hmm?
it is conditional, my lord.
What happened to this WP?
But that WP went in our favor.
When?
Well, I'll get the date, my lord, but that was a case. I know the facts of that case, but it was that many.
And why you are not this thing, madam? Oh,
Your lordships.
so Why you did not offer the land initially, which was mentioned by you? What ground?
Your lordships, the land that was initially mentioned by me and where the field inspection happened, your lordships, it is my own land, my father's land. However, the railways did not give an NOC because it's immediately, the wall is immediately adjacent to it, and a complete all-weather road is not possible into that. That is why the railways did not give an NOC. Now I have taken an alternate land under lease. I've gotten the Gram Panchayat approval and the approval of the owner as well, your lordship.
Is adjacent.
The
Adjacent.
it is not. It is far away from the railway.
No, adjacent to the site initially offered by you.
Yes, your lordships. It is in the same vicinity.
500 meters. What vicinity?
It is about 500 to about 1,000 meters away, your
1
lordships.
kilometer away.
Not even 1 kilometer, your lordships. It's within. It's within.
1,000
The first NOC.
100 meters is simple words, 1 kilometer.
Yes, about that much, your lordships, because the first
It's for them to decide, right, madam?
it was your lordships. The alternate place also was.
Sir, if other person has not set up, he is not coming up here, not contesting, why should you worry?
What follows, my lordship knows, my lord, what follows is then the next person candidate in the draw of lots.
You will have another writ petition. Huh?
If he is not taking, if he is not acting also.
Not acting.
Cancel. You have to
Cancel.
his LOI.
I have, in fact, my lord, between being an officer of the court, I have put that question as to even this, there is a delay, my lord. So what
Yes,
happened?
madam, right?
May,
Wait,
Yes,
listen to
yes.
the order. Heard on IA number 1 of 23 and We have recorded that leased out from Gram Panchayat, etc. She will make available the
Yes, you're right.
particulars of whatever leased out you examine.
Submission is not,
Examine it.
just one, this land that has.
The affidavit shall also disclose as to why an action for cancellation of LOI has not been taken in respect of respondent number 4, LOI allotted to respondent number 4, more particularly in view of clause 5.1 of
Guidelines.
Of,
No, that was.
of the allotment of the LOI.
of the LOI, which is a standard condition in every LOI. As the respond number 4 has failed to complete the commissioning of LPG distributorship within 4 months.
May I also say this.
Go
My,
for a fresh notification. Best thing is, Mr.
I will do that.
In addition, the
So the next successful candidate would automatically come in. So the redraw of lots will happen. So they will.
Now between 19 to 22.
it will be open.
Yeah,
It
launches,
will be
it's been
open
8 years
to
already.
LOI. And it will be open
IOCL.
to
IOCL.
IOCL to
Proceed in accordance with the guidelines. Proceed.
then you say so in the affidavit.
I will say so.
The IOCL shall also state the future course of action which it may adopt with the leave of the court in view of the guidelines framed in this regard.
Deeply
List on
specific in second week of September. Madam.
6th,
12th or 13th.
12th is fine. 12th September.
Yes.
At 12th September 23.
I was unable to.
What's your name?
Dominic Fernandez.
Oh, I also used to appear for IOCL.
I'm aware. We've done
Aware?
the work.
Oh,
You know,
But I,
Your
nothing
lord-
to do with your case, right?
yeah, absolutely, your lordships.
that is
Your
the.
lordships,
I was trying to submit, my lord, that.
So IOCL selects good people right on its panel. Lighter weight,
I'm sure
Certainly.
very good people, your lordships.
very good people.
Yes.
Yes.
She's certified, senior counsel certified. Oh, brother was also counsel, see,
Yes, ma'am.
division bench with you.
And even the second court, my lord, Justice Sam Koshi was also an IOCL standing.
Your lordships, may I make one request? Since I have, since there are documents that no construction activity is taking place even to this day, let status quo be maintained, your lordships, because suddenly
Let's
something,
see. If he starts, we are always here, madam.
yes. I
For any
just wanted to
construction,
bring
there
to your,
needs to be a permission.
We are
Yes,
available.
yes.
Permission obtained. When is it started?
he could have started
No,
since
we-
a long time back.
We are available normally 5 days a week and this week 6 day also.
Yes, your lordships, I'm deeply obliged.
Yes.
May I seek an indulgence, my lord? I was unable to articulate my submission, my lord.
Whatever order has been passed in.
Very well, just
Yes.
very well, my lord. I'm obliged. I will not trouble your lordships.
I'm obliged, your lordships.
Huh?
May it please, my lord.
NCC candidate,
Yes, my lord.
counter,
Yes, my lord. We have filed our counter and vacate state petition.
vacate petition.
Yes,
This is something else, right?
this is something else, my lord, not the batch.
Huh?
This This is is not the something batch, different but matter. something
Batch.
else.
So we will admit it. What?
It has nothing to
It
do
has
with
to
the
be
batch, my lord.
Huh?
It has nothing to do with the batch, my lord. It is a separate matter. This matter is pertaining to the admissions into medical courses of year 2022 and 23.
Today 1:30.
Related
Number
to which
two.
year?
My lord, 22. 22, 23, my lord. By virtue of the interim order, she has been admitted. Now, my lord, she is pursuing.
Ah.
I am ready.
Therefore, she may be.
I am ready to argue the matter.
Permitted to complete the course.
No, I am not saying that. I am ready to argue.
No, Mr. You understand the
Yes,
bench is available only till 1:40, 1:30. So we may not be able to hear it. We will have to give a date.
Immediate subject.
Pleadings are complete.
Yes, my lord, I have one
Pleadings
request to make complete.
Pleadings in the petition are complete. The matter pertains to admission to MBBS course
22-23.
of the academic year 2022-23. Then you say pleadings are complete, petition is admitted for hearing. Let the same be listed for final hearing September sometime, Mr. 14/9.
And my lord, notice has to be issued. Respond number 4, my lord, not yet issued.
Issued, admitted notice to optimistic about things, right? Because that's why we are emphasizing on people that they should come up with synopsis. Here, the senior councils are appearing without synopsis, telling us facts. First MOU, second MOU, you have seen that. So we hope that in days to come, things will improve. In Karnataka, people knew, so nobody appeared without synopsis. So how fast it was, ask him. He is there. Yes. Yes, please.
I'm sorry, may I seek my lord's permission to take out personal notice on respond number 4?
Personal notice on proof of service.
Applies.
Yes. Yes.
My submission is covered by honorable court's judgment, my lord.
Which judgment?
Day before yesterday, my lord, I passed down 2 judgments.
That is subject to lordship.
Tobacco batch.
This tobacco thing. Yes.
The
morning you were trying to seek an adjournment.
We engaged 2 senior counsel.
No, nothing. No senior counsel. No, Mr. This 16/8. No. Please listen to us. 16/8/2023. We had adjourned. All this we had recorded, and you had praised for adjournment to address this court with regard to said issue. That means repeatedly it will not be listed for the same purpose. We will record in the order sheet that prayer for adjournment has been refused. Senior counsel is not engaged to seek an adjournment for sure. And senior counsel everyone knows every senior counsel. I was also senior counsel. He knows that in a pending matter he will never be engaged. Because he will first say that you deal with the court, seek an adjournment, then come to me. This is not this thing done. What you have, just listen. What you have to say with regard to common order, how is it different and why it should be admitted?
Yes.
Please go ahead.
Before that, your actually leaves permit and
of course we have to permit.
Similar matter listed before the Supreme Court as item 14, where the Andhra Pradesh High Court will have shut down the similar notification. The same counsel they are appearing. Therefore, they requested a week time they will come and address the matter. Item 14 that I enclosed the list also. Justice Sanjay Kumar and Justice Sanjay But item 14, Andhra Pradesh High Court, Andhra Pradesh State Government preferred the appeal.
No, what names you are taking?
Similar notification issued.
No, you took the names of some honorable judges. Why?
Sorry.
It's a division bench of the either some High Court or Supreme Court.
Sorry.
No, you were trying to what?
Sorry.
Don't do it.
It will be pending before.
No, it's right. Any order passed by Supreme Court is binding on us under Article 141. It does not depend who has passed the order. Don't say.
Today the matter is there, therefore they request a time to not now be the matter.
No. What happens to this order passed by this thing under this Telangana High Court?
Again, as this ballot.
This is 31/11/21. What happens to this order against SLP? Just a minute. We know that. Against this order, SLP was preferred and this order has not been disturbed. Though it has validity has not been adjudicated, but it has said that SLPs have become infructuous. So why we should not follow this Andhra Pradesh, this our own High Court division bench? Why we are also division bench? So make out a case. That's why that day only we told you it's though you are smiling, you have a serious job in hand. So tell us why we should take a different view than reasons assigned in 21/11/21.
The councillor, I am informed that was become infectious because it is a fresh notification and a challenge.
So same reasons apply to you. This is the order we have recorded.
But your lordship, so please that I'll 30 minutes.
No, you know that 230 bench will not be there, right?
Requested me to bring it to your lordship, I am only bringing it in front of it.
What bring it?
About the same matter pending before the Supreme
No,
Court.
no matter is pending. This is the order sheet we have recorded. This is the judgment of division bench of this court.
Notification, 21 notification.
Same notification, right?
Now this.
Same notification, or is there any difference? Is it not perimateria? Is it not perimateria?
Same notification, my lord.
Same words, right?
Same wording, my lord.
Except date, everything else is same.
Yes, sir.
He wants that all high courts SLP when dismissed by Supreme Court. Then he will argue this one. That's Telangana upheld. So you went to Andhra. Now go to Punjab. Then tell us next date Karnataka division bench judgment SLP is pending.
The first matter Monday subject to lordship.
No, this is listed for your argument only today. And you are seeking adjournment. No, that's what it is.
Absolutely sorry, Vinod.
No, absolutely sorry means tomorrow.
Because requested me to make an adjournment.
Tomorrow, no adjournment. This is and we will impose, this is next week onwards, we will impose cost on tobacco industries and wealthy clients of yours. And deposit, we need funds for this thing. You will deposit in High Court Legal Services Committee for adjournment 25,000 rupees. This is the order sheet recorded on the last date of hearing.
Yes, yes,
Running into, you come here to just this thing, no, to see that our effort is wasted. And every day we should read and you will seek an adjournment. Karnataka is pending, Punjab, Haryana, SLP. Now Punjab, Haryana, SLP is pending. Then it will never come to an end. Against division bench judgment of Kerala High Court is pending.
Independent will argue the matter.
When this will come into this effect, Mr. This notification? 21st March 24, 21st, 20th February 24, it will come to an end.
Yes.
We will adjourn it. There is no stay.
Yes, no stay. Stay is
So no day-to-day basis list after 8 weeks. 8 weeks. Again, we'll say that. For detailed reasons recorded by us in the order dated
May I please? These matters relate to local candidates.
Mr. Rao, it will take time.
Just 10 minutes, it's covered by full bench judgment of Salar.
Tomorrow shall we take up?
The admissions are withheld on account of pendency of the writ petition.
Saturday is a working Saturday. We will fix a tentatively time at 1 o'clock or something like that so that it commences and continues and finished. No, don't seek an adjournment. Otherwise, we will ask them to declare result.
Yes.
Don't seek an, you can't have any choices in this, mister. It's coming up tomorrow. No, we would have heard it, mister. No, we are telling you, we would have heard the case, right? But the bench is available only till 1:30. Even if he starts, you start, you will not. That's why we are taking it up with clear notice to you that tomorrow it will be decided. Whosoever is not available, they can make alternative arrangement for representation. If senior counsel is not available, you represent him or engage any other advocate. Tomorrow, 126 at with your experience is 1 hour. Being a brother adds being a former advocate general. You have been a leader of the bar. 126 pages means 1 hour. You are conversant with the art of vertical reading. Don't go by horizontal, right? So we are sure that you take 12 seconds to go through a page and 1 minute, 5 pages. So we can count how many minutes tomorrow. So we'll take it up. Please mention feel liberty. Tomorrow we will take it up. Definitely. We know an interim order is there. Results have been this thing. List on whatever date. 19-8. Which other case? 7? No. Connected with this 7 is also connected, Mr. Rao.
Yes.
7. 7-19-8. Which other case?
24 Milan.
24. Mr. Rao. 24.
25.
Just a minute. So this all 19-8 tomorrow, right? 24. Just a minute.
24, 25, 26, 27. We are the 28, 29.
No. See, Mr. 26 is already disposed of by an order dated 8/7/2019. This is unfortunate that it is not brought to our notice and then we learn that it has been. So you say 26, don't say anything. It is already disposed of by the WP number 23160/2018 has already been disposed of by an order dated 8/7/2019. Therefore, no orders are required to be passed. Then which other case, Mr. Rao?
27 Miller.
27. Then
28, 29.
28, 29 and 30 also.
30 also.
30.
Not 52 to 47.
1 minute. 1 minute. Let him, then thereafter we will go to other cases.
52 to 57 lots.
52.
52 to 57.
52 to 57.
Yes, sir.
All right. Yes. 19/8/23. Madam. Separate bunch.
Lord, if I may submit, Milord.
20 also, Mr. Rao. 20, 21, 22, 23. All 19/8.
Lord, if I may submit, Milord, subject to my Lord's pleasure.
27.
If I may submit, Milord, in item 29, I am appearing.
Tomorrow.
Challenge, only one submission, Milord.
You don't want tomorrow.
No, I do want.
Mr. Rao.
Milord, the challenge is to an amendment to the admission rules, which is made by the state government. State government is yet to file its version, Milord. No counter is filed. The university, Milord, has come up with its counter. I wanted to submit that to your lordships, Milord. Otherwise, Milord, for that reason, it should not be adjourned tomorrow. I am ready, Milord, in any case to argue the matter.
No. The other cases we will hear. Your case will be deferred if GP for
I
health.
don't
prays
think in
for
any
time.
case, Milord, state has
Right
filed.
now, he has no idea.
In any case, state has not filed any counter. It's
Any
only
case-
the university which has come up. Milord.
No. Why? Because university has given an undertaking. That doesn't mean that we are only hearing. We may be hearing him on vacation of interim order and grant. We don't know.
Very well.
And grant time. If they pray for time, we may grant them time. Obviously, without counter, it cannot be heard.
It is my duty.
So
to
it
make-
is, but Mr. Rao is this thing because he has given an undertaking that we will not declare the result. So he can entitled to argue on interim relief and
Yes.
vacation of interim
Yes.
relief.
Yes.
Yes. We'll deal with it on.
Yes, yes.
My lord, if I may.
The bench is available only till 1:30. That's why, Mr. Otherwise, we would have commenced the hearing just now.
Yes, yes.
If I may make a submission, my lord, lunch motion was granted, my lord. Same may be tagged along with the
Lunch motion. Which case?
file has come, my lord.
Three
WP
matters,
number.
right? Three matters.
One is filed, my lord. Two are pending, my lord. Tomorrow it
No,
will get-
nothing is pending.
My lord, one is numbered. Lunch motion has come, my lord.
All three cases.
Only one has come, my lord, so far. Two I have filed today itself, my lord.
One is pending.
We have granted, right, two cases also.
Yes, my lord.
19-8. Tomorrow? Yes.
Tomorrow.
19. All three. This goes with the bunch, right? Mr. Rao, you get this thing advance copy from him.
I'll serve, my lord.
This council has filed 3 more petitions. Get a copy from him, seek instructions.
Yes.
19-8. Yes. 31.
I'm representing for the petition, my lord, requesting for 1 day, my lord.
No, this is public interest litigation. We will decide. We don't need your assistance. Mister, you cannot, prosecute a public interest litigation like an adversarial litigation and short adjournment. Seek adjournment every time it is listed. Forget about it.
Council daughter is admitted in the hospital, my lord. For that reason, he requested, my lord.
No, we are not asking him to come. Yes. What affidavit, Mr.? Again, Mr. Praveen Kumar. Mr. Praveen Kumar. Live electric shock system should be resumed, right? Nobody is responding. 1/8/23, we gave time to file counter. Nobody is standing up. We don't know whether Union of India is a party, but none of your colleagues are standing up. So this is, who is the person we will direct? Despite, we'll order personal appearance.
Five, 9 to 11, 5.
R5,
And 9 to 11 already.
5 counter 9 to
9 to 11.
Achha.
Those are the private people against whom the allegation is made of illegal construction. So those people filed a complaint.
What they say?
They are saying that all
Who is that? Who has to certify this municipality?
municipality.
Modhpur municipality.
Modhpur municipality.
State government is.
You don't appear obviously, but what to do? Nobody is standing up. Nobody is doing what to do. That's why we know you. That's why we said.
I was standing down for the municipalities. That's
Not
why
appearing.
Reflecting in that.
Who appears?
Municipal administration.
It's a Jagannath Rao starting from.
He has appeared. He is appearing. Name is mentioned in the cause list. Mr. So and so submits that Mr. So and so appears for the respondent, fifth respondent, Modhpur municipality. Office is directed to reflect his name and full stop, list the petition after 3 weeks.
Jagannath Rao.
Not ascension of interim order also.
There is
Ascension of interim order. Ascension of interim order. now.
There is no interim order in pill.
This is public interest litigation, not your property, right? You don't have any idea about the case and you know the interim order. We will haul you up for contempt for misleading the court. Which order dated interim order was passed? When?
I got instruction from the council, my lord.
We will take care of, once we have taken up the cause in the public interest litigation by entertaining, we do not need your assistance. Tell the council. And don't mislead the court. You will, just now you have begun your career, you will be in difficulty, right? This word of caution from this court to you. Don't make factually incorrect statement. without going through the file.
Item 32 KP Vijay Kumar, Certificate General B.
This matter also, my lord, for
Huh?
respondent number 3, my lord, Mr. Jagan Mohan.
1823, UV had granted Harinder Prasad. Special GP had take what steps taken?
My lords, I'm appearing for respondent number 194. My lords, in this matter, my lord, we have to file a
You don't know. Mr. Where is Mr. Prasad?
personal inconvenience, my lord, cremation here.
Huh?
Special counsel is attending for a cremation of his aunt, my lord.
Learn it. Miss, right?
AGP attached to advocate general.
So and so submits that the arguing counsel, Mr. Harendra Prasad, learned special government pleader, has suffered a bereavement. She therefore prays for adjournment list after 2 weeks.
Oh, bless lord.
This bill is filed to protect the government land, my lord. Unofficial respondent showing the private documents and encroach with the government land. There is a rear side of the road, my lord, their land. Road side with the government land, my lord.
They have taken therapy. Nobody appears for respondents, Mr.
Lordship, I am representing.
My lords, MRO filed it, given a letter to the RTO, my lords.
We have taken cognizance. We will take care, right? You lose this thing. Your duty is to bring to the notice of the court this cause. You have brought it. Thank you.
The third
It's not your
respondent.
property, right, which is being encroached. Everybody's property. Yes. What about this thing, Mr.
I appear for the third respondent.
Director Planning HMDA?
R2 HMDA file counter.
Para 3 has been, it has, what has been said, you read.
R2 HMDA file counter.
Huh?
HMDA file counter, my lord.
The local body, my lord, HMD had filed its counter.
Huh? No, we are not concerned with who has filed. We are concerned with who has not filed.
But the R3, my
And
lord.
para 3 of the stand you see HMDA.
Yes. But a week's time, Lord, I'll get back to the instructions, Lord, counter.
Then you should say, right?
Maybe, I'm sorry.
My lord, may I make permit? One
A
permit.
week's time, Lord, I'll get back to you, Lord, sir.
In view of the stand taken by HMDA, Hyderabad Municipal Development Authority in para 3 of
My lord, only, my prayer is very minimal.
No, the government land will not disappear.
It is a very small
No.
place.
Government land, do you think that within 2 weeks it will disappear?
My lord, they already constructed a command. It is a report from the MRO to RDO with lordship permission. One report, my lord, with lordship permission.
No, not, this is along with a memo, not like handing over documents in the trial court.
My lord, I have
This-
filed a memo of the proof.
We will not permit filing here.
Additional materials of submitted in the memo of proof.
So
My
what
lord.
do you want? I mean, that they should go to jail today.
My lord, only,
It should be demolished. We are not prepared to do so.
my lord, only if the government revenue department, if they pay.
No,
to the
so
government.
you are in intending allotment of that government land, right? So you have filed a PIL first to fence that, thereafter to make an application for allotment of that government land. This is what PIL is about.
Not my lord. My lord, the unofficial respondents polluted with official respondent and their private land is rear side of the government land. They're showing their land details and their
No, Mr. C.
government land.
We have granted 1 and 3, 2 weeks time to file counter. If you are aggrieved by this order, remedies northwards. Challenge it before Supreme Court and say that High Court should not have granted 2 weeks time and should have allowed my petition. We will see whatever order it's.
My lords.
Respondent number 1 to 4, I'm representing your lordship, requesting time for filing count.
2 weeks time granted, madam. We will direct this thing. Pass appropriate orders against you if you don't file it within 4 weeks.
Your lordship may say 3 weeks, your lordship meanwhile will file count.
Learned count so and so appearing for.
Appearing for additional advocate general office, your lordship.
Which respondent, madam?
Respondent number 1 to 4, your lordship.
1 to all respondents. So say
Unofficial respondents are there, your lordship. 1 to 4,
respondents 1 to 4. Pray for and is granted 4 weeks further time to file the counter, failing which appropriate order shall be passed on the next date of hearing.
Much.
Appearing for respondent number 2 to 4 in this matter, madam. The status report is ready, madam. We are filing it tomorrow. Lordship, I have it on Monday, madam.
Learned counsel for the
GHMC, madam.
Undertakes to file the status report during the course of the day.
Tomorrow,
madam. By tomorrow.
Monday.
List in view of a forces submission list after 1 week.
Bless.
Yes.
Your lordship, I appear for the appellant in this matter. This appeal has been filed against the order passed by the commercial courts, special commercial courts on 1st July 2022. The order was passed wherein I was set ex parte, and the order has been passed under verdict.
Heard on IA 1 of 2023. Issue notice to respondents, personal service, whatever, and proof of service.
But in this case, state of AP file counter. Yesterday only they served, but there is state of AP and state of Telangana. Both of them are parties. Telangana filed their counter, but direction was given to AP. They filed yesterday. But I running into almost 20-25 pages. But I need some short time for filing reply.
All right. Petition is admitted for hearing. Learned senior counsel for the petitioner. Praise for is granted.
2 weeks.
2 weeks time to enable him to file reply stroke rejoinder.
Okay.
38 to 42 all counter, right? 38.
May I please your lordship?
Let counter if any on behalf.
3 and 4. One submission, my lord. After filing of this
38.
38, my lord. After
Your
filing,
grievance stands redressed.
my lord, they have passed an order, my lord, where relieving order is passed, my lord. After filing of this writ petition, they have issued the relieving order, my lord. I will file it.
Learned counsel, give it.
Yes,
There is no point in sending the file back. Learned counsel for the petitioner submits that the grievance of the petitioner in this petition is redressed as respondents have issued an order.
I will file an amendment, my lord.
No. Petition is itself is disposed
No,
of.
my lord. No, my lord. After filing of the writ petition, they have issued the impugned order, my lord. I will file an amendment to that effect, my lord.
We will record granted liberty, file a fresh petition.
My lord, in fact, already this this impugned order is challenged, but it was listed before a single bench, my lord. I will withdraw that. I will file an amendment in this because state of AP is also necessary, my lord, in this way.
If that court, the
Yes, my lord.
judge does not have roster to hear, bring it to his lordship notice that the matter involves both the state, therefore it has to be listed before DB. But you need not file one more writ petition or amend. This writ petition gets closed. You can make a mention before the learned single judge that this involves both the states. Therefore, it should be listed before the court having roster. That's all.
Yes, very well.
So this we go with the liberty. After hearing learned counsel for the petitioner, since the petitioner has counter.
Yes, Lordship, may grant 2 weeks for the counter, my lord. I represent for second and fourth respondent.
Status Telangana.
Don't want to say anything. Learned counsel for respondents do not want any time to file counter. The petition shall be heard on the next date. Yes.
Lordship, 3 and
Again, standing like looking at us. See the thing, Advocate General has to be called live shock system again to be introduced, because you people don't respond and under a state of shock, or we don't know why you don't say anything.
Sorry. Sorry.
Mark their presence, Laureate Council for respondents pray for and are granted 4 weeks time to enable them to file counter.
So I'm appearing for respond number 3 and 4, my lord. Need to file counter in this.
3 and 4, praise for and is granted 4 weeks time to enable him to file counter.
This matter goes along with yesterday, my lord,
Same order,
conducted matters were.
You are 3 and 4.
Yes, in this matters, respond number 2, my lord.
Respond number 2, praise for and is granted 4 weeks time to enable him to file counter. This goes along with who, which?
13, all the batch matters were posted to 13 September. man.
List on 13 September 23.
Published.
42 to approve. So then petition 41 admitted for hearing. Yes.
Mate, please. Lady.
I'm appearing from the respondent number.
Infructuous. Infructuous.
They have taken back the land.
Yes, my lords.
Huh?
Yes, my lords.
So it is restored
Yes, my
back to
lords.
junior college.
Yes, my lords.
Please
That's-
give it to us.
These are the proceedings, my lord. The counter has been filed by the respondent number 8 by mentioning, my lord.
Right, it has been restored. Your purpose is served. Now you can be at peace with yourself. That government land restored to government.
Government Vice College, my lord.
Find out.
Integrated vision.
No. Now find out another public cause to prosecute. If you need public interest litigation to survive.
Last page of set of papers, my lords. Proceedings.
What is the order?
Date of 19/7/2023, my lord. Proceedings of the district collector cancelled.
Even this one. This one. In this writ petition, the petitioner inter alia has assessed the validity of the order dated 9/12/2022 by which respondent number 4 has handed over
But we have.
Bar Council of India, you are Bar State of Telangana.
State.
What do you say?
We have commenced disciplinary proceedings against the respondent number 8, YD's case.
Learned Council for State of, Bar Council for the State of Telangana on instruction submit that a disciplinary proceedings has been commenced by the State Bar Council against respondent number 8 and shall be brought to its logical conclusion by how much time?
Your lordships may fix some time.
No, you say it's volunteer.
In the ordinary course, it will be a period of 1 year.
That's why we don't want you to keep pending and then say refer it to Delhi after 1 year and that nothing happens.
Actually, there is no reference to Delhi. People from Delhi come over. That's
whatever. But what is effect of non-pendency beyond 1 year is something else which probably things go beyond your control. We don't want it to go out of control. Learned instruction, State Bar Council submit that a disciplinary proceeding
have been commenced.
has been initiated against respondent number 8 on.
But it is YDC case number 14 of 2022.
2022 on.
But I do not have the date readily.
He shall apprise this court about the status of the disciplinary proceeding and the time limit within which the same shall be concluded, as respondent number 8 is a member. Council, State Bar Council. What time?
Your lordships may give me 3 weeks for.
2022, already 23. 1 year is over, right?
The difficulty in this matter is that the respondent number 8 is in judicial custody. He is not able to respond to the notices.
No, the judicial custody means video conferencing facility not available in jail. We think it must be available in all jails. Yes, sir, come up with the.
Bar Council does.
You hold a Zoom meeting, whatever. Do it.
Very well.
There are ways and means. If there is a will, there is a way. If you don't want to do it, this all custody and all that.
This case is a suo motu initiated case. Therefore, there is no.
Therefore, we are as an officer of the court, we are asking this. This sort of a behavior cannot be tolerated for a second from anyone. We have immediately placed an employee of this court under suspension on similar complaints, and he'll be facing a departmental inquiry. As an officer of the court, you will agree.
I will certainly.
So therefore, you should tell us what date. Earlier on. 30th August 23.
Very well.
Please inform.
I am obliged. May I please?
The applicant in item number 45.
To fix an early date. So next working Saturday is the earliest date of this case.
That may not be necessary now. In fact,
Later when we said at least you can.
Your lordships will
To fix an early date.
But that application can wait. I will find by then. We have filed it because.
You want some direction.
There are some directions which they are now required to report to the court. Lord, if your lordship takes up USR number 30084 of 19, I've given the slip. No, there is a brief note, my lord. So there are several orders passed from time to time. We have consolidated them. It's already filed on record. In WA 656 of 2017, there is USR number 30084 of 19.
She said what she has done. Highway direction. Highway should be solved within a year. Right, written bond.
Both of sir. The
This is
30084.
No, 12th June 2019.
No, Mr. Senior Counsel. No, we must be fair to you. This the cases which are listed under interlocutory caption, we don't read it. So we have to be honest to you in telling that we don't have any idea what is the case about.
That is why we are just, I briefly
So
state
what
5
is to
minutes.
be heard finally?
No.
What, the IA?
It is
Which IA requires consideration?
But
You
your
first
lordship,
tell us.
I have filed a consolidated memo that will be convenient for your lordships to. USR number 30084 of 19.
When?
12/6/2019 is there.
This is the old one.
It is dated
2019.
12th June 2019.
Yes, we have it.
After that, the matter has not been listed.
What is this memo about? What is this case about?
But I just give a small backdrop, not before I take your lordship.
Second, Mr. Yes, because they have been taken up revenue officials. They are the petition. So they gave taken up. Taking any urgent ones for officials. Yes.
Just speak back of 2 minutes and take. But what happens? There is point number 30. I'll refer the parties are there arrayed in the writ petition for the lordship. Just 5 minutes before I take your lordship to the orders. I refer.
This is the result there. We have been requesting all senior councils, if they want order, give a synopsis so that all this is, we don't need this pad. So we will have to write what all you say. Because those facts have to be dictated in the order.
May I request for
petitioner. No, I just.
My lords, I will be seeking for an adjournment on these matters. My lords, the disciplinary inquiry as directed by this honorable court to be initiated against the former district collector. My lords, I am instructed in the morning that they have proceedings were initiated. I will have to, my lords, apprise your lordships about the stage of that. I will have to have a written instructions. May I request your lordships to take it out
regarding.
If that is, my lord, placed before your lordships, my lords, as far as the disciplinary inquiry against the district collector as ordered by this honorable court, single judge order which was upheld by the honorable division bench. My lords, I will apprise your lordships with regard to that, because after a long time this is listed at their request. I will also, my lords.
But I have no objection granting time, but there is one more aspect.
Which order the court had, single judge had directed?
I'll just give 2 or 3 facts, my lord, before, otherwise it would be an abstract. There are 3 orders which are now required to be complied. 1 second. My lord, initially, my lord, I'll just give it 5 minutes, 2 minutes background. So far the writ petitioner is concerned. The writ petitioner claimed land to an extent of about 5,200 square yards in the midst of the Hyderabad city. He claims to be the owner.
Who you claim to be owner?
The writ petitioner. Who is the now appellant in WA 693 of 2017.
So he was seeking a declaration of his title in the writ petition.
Not at all.
That
what happened? Respond number 13 to 15 in the writ petition. Make an application to the NOC committee district collector, who is the
13 to 18.
13 to 15.
15 in this writ appeal.
No, writ petition. I am referring to the party
Which
side there.
petition?
That is WP, out of this the writ appeal arose. That is writ petition.
This one order, several writ appeals, common order.
Yes, that's why. That's why WP 766 of 2011.
Will you be kind enough to give us a synopsis so that the time is saved?
Your lordship, that's why that memo is there. I am afraid.
Yes.
May I pass on, otherwise I have made one more copy.
One more copy.
Okay, got it. May I pass on extra copies?
No, we have. Yeah.
I'm sorry. May I read it for my convenience? All the above writ appeals are out of orders in WP 766 of 2011. Now WP 766 of 2011 was filed by one Srimati Shanti Agarwal. The respondent number 1 in WA 656 and 686 and the appellant is for the following relief. And then consequently set aside recall NOC bearing number so and so issued by them in favor of respondent number 13 to 15 herein, and also direct response to demolish the illegal constructions made by respondent 13 to 15 on the land of the petitioner herein situated at so and so. Awarding damages of rupees 1 crore to the petitioner, initiate appropriate criminal discipline proceeding against the concerned respondents and pass. But this WP was disposed of by the Honorable Court, and the operative portion is at paragraph 68 is extracted. So far as the NOC is concerned, that was declared to be as null and void.
Is reputation. Inclusion are 16.
But I may give one subsequent event also to your lordship's notice. Page 3 of this note. D mirror, WP number 8928 of 2011. But that does not survive for consideration now. At page 3. This is a subsequent event. This will not survive for consideration because this part has been set aside by the Supreme Court. Because this proceedings arose out of criminal proceedings, appeal was not preferred here.
Yes.
So far this but paragraph 7 is relevant.
So they have to, first thing is they have to apprise about the disciplinary proceeding initiated by them against the erstwhile district collector.
That is one aspect.
What is the other aspect?
This, so far as this aspect is concerned, last time we had pointed out, just to apprise the Advocate General so that he'll take care of this matter. We had pointed out that I am the complainant. They have never examined me. Last time they said they will take steps to examine me. Now,
examine you in what? D against former collector.
The disciplinary proceedings, because I am the author of this complaint. Now, last time Advocate General said he'll look into it and see that I am examined.
We have advised, my lords. I will just, my lords, apprise.
Now, today the progress is that the same collector is now in charge of the revenue department here. He is now the principal secretary.
That he will see. Yes. What third is?
Second thing is, so far as the criminal proceedings are concerned, 13 to 15, we have said 13 to 15 are non-entities. They are only name lenders. They are white ration card holders. They are people who move on bicycles. The people behind grabbing this land are some other people who are influential people. And we had given clearly in complaint that the money flow shows that money never came from them. Now, what happened after grabbing this land? After they arrest,
these two issues we can address today, and I had to ask Advocate General.
Yeah, that's why I'm afraid.
To third one, you keep it slightly appears to be contentious about money trail.
Well,
and
why I'm saying that
we can't decide today.
No, why I'm saying that is, now a truncated charge sheet is filed against respondent 13 to 15, as though they have involved themselves in cheating. But they are non-entities. Out of them, 2 people have died, 13 and 14.
So this court has power under 319 of CRPC or something like that. You filed against some complete 173 further investigation. You have powers under this thing, no? Anybody? Court has.
Tehsildar is the complainant. The complaint was directed. Now, the other aspect is this honorable court had directed Chief Secretary to lodge a complaint.
340, my lords.
Now, the Chief Secretary never lodged a complaint. I'll just apprise not how the sequence has happened. Lordships may have to, CRPC may not.
No, the only thing is we would like to do so, but benches you will realize why we are hurrying up. See the time. The bench is still 1:30. We would like to, it's a pleasure to hear you.
Would you not consider having it tomorrow? I'll just take another.
My lords,
He's paying.
Praise him about so that he will take action on the criminal side also. Now the chief secretary was directed to, I'll take only 2 minutes. Chief secretary was directed to lodge a complaint. Chief secretary never lodged a complaint.
Where this court had directed.
This court had directed. Now what they did is the Tehsildar lodged a complaint. Enclosing the order copy passed by the Honorable Court.
Direction of para 68.
Yes.
Where the direction to chief secretary to lodge.
First respondent is directed to initiate, respondent number 1 and 2 shall initiate prosecution against respondent 13 to 15, which is at page 2 of my note.
Yes, yes. All right.
So then this Honorable Court on earlier occasion once again directed them to see that chief secretary should oversee everything. Nothing is done. And we are repeatedly giving letters to them. Please look into this. So let my advocate general look into it. That's enough.
Yes, definitely. Learned senior counsel from the petitioner.
Sensitize my subject. It was more to sensitize my senior colleague on the seriousness of the,
Mr.
so that he'll look into it.
He always takes everything. Yes.
But I'm certain that he'll look into it.
Please.
Subject to my lord's kind permission. Subject to my lord's kind permission. I'm appearing for appellant in serial number 45 in the same batch of matters. I am for the district collector against whom inquiry is ordered. My humble submission is.
Advocate General has this thing. Yes, he will tell us what has happened to the. You tell us that what has happened to you.
My only request, minutes. Let the inquiry be expedited because for last 6 years.
That's what he will tell us.
That is initiated.
When an Advocate General says that I need time, that he has said that instructions have already been issued. But before formally making a submission, he is praying for time. We appreciate your predicament. 6 years.
His promotion is stopped now. That's his.
Yes, promoted, not stopped. He is now principal secretary for revenue. Which department is investigating into this? He is put into the same department. This is an irony, Mirat.
My lords,
So your burden is lighter when the council is there. You should ideally stand with him, not here with the petitioners.
No space on that side, and I'm there.
No, maybe
it's no. It gives us an idea that he's sailing with you.
Excellent. That's the reason I came to.
Certainly, he's sailing with me. So far as law and facts of this case are concerned. But he's out his right. That's all.
Yes, lighter weight. Mark the presence. How much time, Mr.
My lords, as far as to appraise your lordships and the disciplinary inquiry which has been commenced, my lords.
All three aspects.
My lords, I will just take the written instructions.
The complainants have to be examined in the departmental inquiry against respondent number 8.
Yes.
Right? Yes. Learned senior counsel for the appellants have made following submission. supervise that.
Supervise it, and a proper investigation is required to be conducted.
And a proper investigation is required to be conducted. Paragraph, in view of aforesaid submission, Mr. B.S. Prasad, learned Advocate General, praise warrant is granted.
My lords, 2 weeks time, your lordship will grant, so that, my lord, I'll file a report on the,
That 2 weeks
on the stage of the, my lord,
we
disciplinary
seek
inquiry.
instructions and to file a report on the aforesaid aspects of the matter. List on 31st August 23.
One small subject.
Obliged.
Preparing the dictation. Your lordship dictated that on 1/11/18, one SLP was dismissed as infractious. On 22/11/18, the other SLP was dismissed on merits. That sentence also would have to come.
Acha. 1/11/18 infractious you have written, madam. Thereafter, right, another SLP was filed by applicant number 1.
That is SLP 33.
No. Another SLP was filed by whom?
Lord, there are three appellants filed 3 different SLPs.
Another SLP, namely SLP number
861
bar 2017, was dismissed by a speaking order on 22/11/2018.
Sorry for the inconvenience, sir.
No, but you did your this thing. You gave us the synopsis. That's what we wanted.
Yes.
But this was 45. This was 47. 44 to 46. Yeah. 47 and 48 left.
In this matter, respondents, my lord, 456 has filed a counter and vacates the petition. Respondent number 456 have filed a counter and vacates the petition. But I am representing for the appellant. My lord, the appellant is the writ petitioner. He filed a writ petition on the ground that his application was rejected. But the
applied for respondent list of dates, but so that you
No list of dates to.
I'm passing it on. I'm for respondent of 5.
See the time.
I'll leave it to you.
1:40.
I'll leave it.
Not possible. If it's that urgent, then we will have fixed a date.
I filed vacant, but the urgency is there. There's an interim order operating against me. Whenever your lordship can make.
2021, since when it is operating?
But it's operating for last 2009. It's there, but I'm not going to the urgency is that.
This all, we have a table in front of us like this, all dates given matter. So we look into it and then fix a date. Very this thing.
No, at the earliest, I can do that only at the earliest.
Yeah.
Because my construction has been stopped. But that's
they have the encroaches of the property.
We'll here, we are only fixing a date.
Yes.
5th September.
I'll leave it.
Please give a synopsis.
Yes, I will do that.
Mark the presence list for consideration of IA 1 of 22 and IA 1 of 23 on 5th of September 23. Right.
Obliged.
40.
Appearing for the petitioners, my lord. PIL filed,
This cricket association.
Hyderabad
Right?
Cricket Association.
You got it, this thing.
Yes, my lord. My lords, the issue is pursuant to the order passed by the Honorable Supreme Court, Mr. Justice L.
We
Nageshwara.
know that. He has conducted an inquiry, submitted a detailed report,
Yes, ma'am.
and therefore you said that the PIL should be closed.
My lords, those were my instructions. I'll be obliged to assist this Honorable Court if the Honorable Court is inclined to monitor the functions.
He said that he himself is a cricket player and wants the criminal prosecution to be launched against
My
those
lords,
who have.
I'm deeply obliged to be able to assist this Honorable Court on it, my lords. I'll be deeply obliged to assist.
That has been done. But he says only issue is that prosecution. He wants prosecution. Has he in the inquiry report, Honorable Justice Rao has stated anything about prosecution? Why do you need one thing, Mr. Do you need a court's direction to prosecute, or you can prosecute?
My lords may appoint.
You can file a complaint, right, against whosoever has defalcated or misappropriated the funds of your academy or whatever association and proceed against them. If Lalita Kumari, if your complaint discloses this thing cognizable offense, police, we are sure that it shall register a first information report. It's constitution bench judgment.
May explain two issues, my lord.
My lords, before the.
No, that's what we are. Now the only grievance is that FIR should be registered.
May I
So
say
you
this?
file a complaint.
May I say this, my lord?
We grant you the liberty to file a. See, we will hear you, of course, sir. What we are saying is that we grant you the liberty. You agree that whatever she is saying is correct. All this thing, report submitted, elections held, newly elected office bearers are in place. Whatever action, the action, requisite action in terms of the report submitted by Honorable Justice Rao has been taken. That you don't dispute. Now, last date of hearing, when she got it listed on a mention memo, we remember that you said that I want this thing, criminal case to be instituted against those persons who have misappropriated the funds of the association. For that, you are first required to file a complaint. You file a complaint and the police officer shall, if it discloses commission of a cognizable offense in the light of law laid down by Supreme Court in Lalita Kumari, the action will be taken on that complaint. Simple.
My lord, I have circulated.
In addition, that you are a respondent, right? Anything else?
Respond number one, my lord. My FIRs need to be investigated.
No. So, anything else in addition to this? Because this grievance stands redressed that you will file a complaint against whosoever. That police will take action in constitution bench judgment. They know it. We are sure that to all the police officers, constitution bench judgment must have been circulated. That if complaint discloses commission, FIR has to be registered.
May explain two issues, my lord.
My lord,
My lord, two ACB cases were already registered and charge sheets were filed, my lord. They were not being proceeded. My lord. Subsequently, another complaint has been registered, my lord, at the instance of one of the office bearers, my lord, for misappropriation of funds. My lord, all these were taken into consideration, my lord, with the background of the fact that the.
Where is the report, madam, submitted by?
My lord, it's a seal cover report.
Where is it?
We do not have it, my lord. It has been
No,
submitted.
my lord, I'll explain, my lord. After this bill has been filed, my lord.
Okay.
My lord.
We can't see this. And that copy of report is not available?
That's what, my lord. After this bill has been filed, my lord, as per the orders passed by this honorable court, my lord, a forensic audit report has been placed before your lordship, which was placed in the sealed cover in the custody of judicial registrar. My lord, in that, my lord, subsequently, this honorable court has observed that as per the audit report, there are severe irregularities of misappropriation.
No, with regard to.
You are the association, right?
Yes, my lord.
My lord.
Who will lodge a complaint if your funds have been misappropriated? Correct?
True, my lord.
Who will lodge a complaint?
My lord, that's what we are saying, my lord. Now.
You will not, you can't lodge.
My lords, my lords, if I may be permitted to say this, my apprehension for when my instructions were to withdraw this petition, my apprehension was they were one set of office bearers earlier, my lords. After elections, by way of monitoring by Justice Rao, there was another set of office bearers, my lords. Now, this PIL will be used as an instrument of two rival parties fighting, my lords.
That is correct. But what you should do, we have been telling every senior counsel, what should you do? You are here to assist the court.
Yes.
What should you do? Give us a chronological list of events, 2 pages, then we will hear. Because he is opposing your prayer. What can be done?
My lords, if this
He wants.
client
had circulated the sequence of events, my lord, that's part of the report. With dates, my lord. My lord, I'm not opposing the prayer, my lord. I'm supporting the cause, my lord. Stating that.
No, but she said that it may be closed. You oppose. No, it can't be closed. Last day. In that sense, you are opposing.
May I request one thing? This may be taken up tomorrow, my lord. I'm not insisting for a CBI inquiry, my lord, but some investigation agency
my lords,
to take
instead
up
of
the onus.
tomorrow, I may be permitted to, since it is my petition, I will prepare a synopsis.
Not your petition.
My lords.
No longer your petition.
My
This
lords,
is
petitioner council, my
court's petition.
I will
That's
call
what we have
bona
been
fides.
That's why, madam, as an officer of the court, all times you owe a duty to assist the court and to function in such a manner that more efficiency is brought in.
Yes.
Not like that this association was formed in the year 1857. So and so was the first president, his term expired, thereafter elections were held, not like this.
I'll circulate a list of dates and synopsis.
There in the petition,
Yes.
what action has been taken and say clearly that this is how our grievances stands redressed. You say how it survives.
Yes. That's what. 1 week may be granted.
So you can tell us that how the grievance of the petitioner has not been redressed and what else is, in case you have an independent cause of action.
I'll satisfy your lordship on that.
No. Please think it this way also. In case you have an independent cause of action, you are at liberty to take an action before a forum in accordance with law.
My cause of action, my lord, to support the investigation, my lord, starts with the report of the PCCI,
No,
my lord.
Mr. That means what is intriguing is that though you say that I support the petitioner.
No, I'm not.
Not support.
I'm saying, my lord, that this investigation need to be done into the irregularities that were committed, my lord.
So, Mr. This all is concluded by orders of Honorable Supreme Court and the report submitted. You are agreeing at this point of time that report has been given effect to, correct?
I'll clarify this aspect, my lord.
So then if you are aggrieved by the action taken report pursuant to this thing, you challenge it. Perhaps this court is not the forum. And this in PIL, perhaps we cannot.
I can understand.
Bring the orders, madam, of Supreme Court appointing this thing, then action taken report, then orders. What orders Honorable Supreme Court has passed?
Technology of dates with the orders passed, my lords. Along with the orders. Several orders have been passed by this Supreme Court and the Supreme Court.
And you say that these are my prayers. This is how action taken report is. This is how it is redressed. Then we can perhaps be more specific in asking him
1 week.
how he is his grievance. How he says that your grievance is not redressed. Independent causes of action.
I have filed the order of the Justice Rao, my lord, as R21. It is categorically.
No, that you say report is in seal cover. Where from have you got?
No, my friend, I'll explain. The seal cover is audit reports, my lord.
Even to destroy the report that is submitted by Justice Rao. You may be getting them on. Don't need ever lyric. There is statutory right to file FIR in case there is an embezzlement dispute. And then how in a responded when a thing relief can be granted to you.
Mr. According to our understanding, the basic thing is respondent in a petition cannot prosecute his independent cause of action, and he should have you take recourse to the remedy available to you under the law. In this public interest litigation, you cannot say that to take an action in respect of misappropriation amount is your statutory right. You can file the first information report. Nobody can deny. The Constitution Bench judgment of Supreme Court will govern the fate of your complaint. Why do you want the direction of this court? In a public interest filed by somebody else.
May I explain that, my lord? May I explain that?
That's what.
I'll satisfy your lordship on that, my lord. I'll satisfy your lordship on that.
Can you first of satisfaction in an PIL? Can you be permitted to prosecute your independent cause of action and insist that relief to you in a PIL filed by somebody else should be granted? So what relief you are seeking? That's what we want to know.
Great respect, my lord.
No, first tell one sentence what relief you are seeking in this PIL.
Lord, to implement the orders passed by this honorable court basing on the observations made by the committee of arbitrators appointed by this court, stating that this is what need to be investigated by an independent agency.
No. For implementing the orders of the court, you need permission of this court. Why?
Criminal investigation. I'll read the report, my lord.
No. We are only asking you this thing answer. That for implementing the directions of this court, you need permission of this court.
I say this one. Committee of arbitrators appointed by this honorable court has relied upon the forensic reports given by the Ernst & Young Chartered Accountant. Basing on that,
Madam, we'll proceed.
Yes.
Perhaps it can't be. You see, the time can't be done now.
Very well. At your lordship.
On account of paucity of time, the matter could not be taken up. Learned counsel for the petitioner undertakes to prepare chronological list of events along with orders of Honorable Supreme Court and relevant documents. It should not run in 100 pages, right?
Yes, ma'am. I'll make it concise and short.
So otherwise that itself like,
I'll make it concise.
then he will file 150 pages.
No, I have already filed, my lord.
We will have one volume of submission
I'll make it very concise.
with which nobody is concerned, right? Everything has been done.
Concise.
My lord, I have already filed, my lord, on 1710 synopsis, sequence of dates. I have given it.
So now, as we understand, now it will be, we'll give a date. This thing, you seek leave of this court and you don't want this petition to be disposed of because you want leave of the court to implement the directions of this court, correct?
I'll explain 3-4.
No, this is what it is, you said.
Yes.
You will, of course, but we want to just understand, right?
Yes.
We will remember it on the next date of hearing. So when we begin that, you want leave of this court to prosecute directions or issued by this court. This is in substance. Huh?
Alex.
This is what you want, right?
But I want a criminal investigation independently to be done by the central agency because
Independent, that's what we are saying. It is an independent cause of action, which cannot be granted to respondent in this principle of law that in a writ petition filed by, forget about PIL, somebody else responded. No. This principle of law, first case we will hear, the first decision you should cite that in a writ petition filed by somebody, a respondent can prosecute its own, agitate and prosecute independent cause of action for handing over CBI.
I'll explain.
I'll
explain, my lord.
First thing. And
Yes,
second thing, you said I want liberty. This is something else. First is saying investigation for misappropriation be handed over to CBI is something else. Second is saying that I want leave to prosecute, to implement the orders of this court is something different.
My urging, my lord, if not CPI, my lord, a SIT can be constituted and the court can monitor the investigation.
That will be gone into in an appropriate proceeding at your instance.
Yes. I'll take steps, my brother. I'll
That's what it is, Mr. So, right? But still, we will not hurriedly close it up. But this is the point. I mean, we are granting. We can understand that your case grievance is that it should be handed over to CBI and all that. But that will be done in an examined in an appropriate proceeding, not at the instance of respondent in a PIL. She has no locus to withdraw the this thing. PIL Sheila Barse. So should say, you don't know. Sheila Barse, you don't know. Then why did you say that I want to withdraw PIL? Nothing, you can't withdraw now. That's that is something different, madam. Please understand that grievances stands redressed and suitable orders be passed is something different than saying I want to withdraw PIL, which we can't do in Sheila Barse versus Union. That's why you have the potential to improve. That's why we are spending time beyond the. So when, Mr. Give an agreed date.
Monday.
Whatever my brother says. Date.
No. Learned Senior Counsel has circulated a memo to us of the list of dates, giving the date as 17/10/2023. So we'll have to wait till that date.
What happened instead of 17/8, 17/10 has been typed. Huh? (31/8). Okay. Madam, know this thing. Huh? You will not take more than 5 minutes on that. Yes. Board will continue. Board will continue. Board will continue. Yes.
This is got agenda. Morning they were mentioning 51.
No, this side. Adjourn and rest of whatever continues, madam. Everything continues. 58 is hearing, right? Huh? So why are you calling? Everything else which is not called continues tomorrow, right?
Continues.
Tomorrow.
My lord, there are IAs pending which may be taken up sometime in the third week of September.
All right. When do you want?
Third week of September, my lord.
All right. Yes, madam.
Please, Your Lordship. On behalf of Deepak Mishra, ma'am.
For respondent, I filed a memo of objection to the report of the receiver.
Huh?
I corresponded, but I
You have filed the objection.
objection report. I have member of objection already filed.
All right.
Deepak
Taken
Mishra.
on record.
I'm
You are which you are respondent.
For respondent also. For all.
Only respondent.
Yes, for all respondent.
All respondent.
That memo is also there.
I intend to file a reply on the objections, my lord. Request for the 2 weeks time.
All right. Learned counsel for respondents state that he has filed objections to the.
Memorandum of objection I filed.
Yes. Memorandum of objection to the report submitted by the receiver.
Commissioners.
Receiver cum commissioner. Learned counsel for the petitioners.
723.
Praise warrant is granted. How much time?
2 weeks, ma'am.
3 weeks time to enable him to file objection.
Much obliged.
Appearing for the respondents matters. This item number 156 and 157 are connected matters, my lords. I request your lordships to kindly grant 2 weeks time for filing counter affidavit, my lords.
Well,
this
may I tell you, Lordship, these two items, 156, 157, they are concerned with CS number 7 of 1958 and item number 252, one village by name Shamshiguda, survey number 57 is the subject matter of these two applications. Well, in respect of this item 152 Shamshiguda village, final decrees were passed earlier and the petitioner is one of the persons, respondents 4 and 5 are other persons who are having final decrees for different parcels of land in the same survey number 57. Well, what I beg to submit is this, Mallet. The government I request my lords to kindly take the next case 7153 of 2023. 7143 of 2023. The government, my lord, selectively has been deleting this land from 22A under the Registration Act and also
you have filed an application for conversion of the land
to
non-agricultural purpose on 27/12.
That will be deferred, my lord, because I cannot press that writ petition in view of the subsequent report submitted by the advocate receivers dated 6/7/2023. Therefore, that matter 5150 of 2023, my lord, may be deferred.
That's what we are taking it up.
Next item he mentioned.
Deferred. This will be deferred. Why?
By about 4 weeks.
Why it is should be deferred?
No, for filing objections to the report of the advocate receiver.
In this writ petition.
No, in this writ petition, the number is. Well,
No, we are only talking about 5150. We saw
5150. 5150 is about inaction on the part of the state authorities in considering the application of the petitioner who is a final decree holder in respect of survey number 57 of Shamshiguda village, which is one of the item in CS number 7 of 1958.
So
that is the cause of action.
No, fine.
After
your grievance is that they are not taking action to convert the land. Then you said that it be deferred. We want to know why it should be deferred.
Because after I filed this writ petition on 6/7/2023, the advocate receivers have submitted a report in CS 7 of 1958 to the effect that this Shamshiguda village to which the writ petition pertains is one which is
not released by the government and hence not available for partition and not eligible for grant of final decree in CS 7 of 1958. This report is dated 6/7/2023.
All right.
And the Honorable Court also said that parties aggrieved will have to file objections to the
It
receipt.
has to be deferred till adjudication on report.
I cannot
to
press
the-
this repetition on that
correct.
ground.
Mark the presence, learned senior counsel for the petitioner.
And respondents 4 and 5 are claiming 92 acres in survey number 57 of Shamsheguda village.
Appearing for the petitioners, my lord. I am appearing 158, 160 and 161 are connected matters.
Incorporating your name.
No, Miller. They have stated, Miller.
It is rejected.
Online application has to be made. Manual application will not be accepted. And
Copy of that.
permitting the petitioner to make application.
No, not you withdraw the petition in the light of communication to file.
Basic, 18723 order, Miller, your lordship's mechanic. Endorsement, Miller.
No, correct.
18723.
Correct, Mr. For submitting an online application, no leave of the court is required. I don't think.
Receiver and commissioner submitted.
So if anybody files an online application, they can do so only with our consent.
No, I'm not saying that, Manas.
We are asking you.
No, Manas.
No permission of the court is required.
187, your lordship's mechanic.
Moreover, my lords, now that
18723.
Moreover, my lords, now that receiver and commissioner submitted its report, my lords, let the lordship may direct the petitioner to submit the objections, if any, my lords.
He is opposing. You have not. Have you?
Blood NVF subsequently, blood.
Nothing subsequent.
Blood NVF subsequently, blood.
Nothing subsequent, then you have to place it on record. State. You have to challenge this order dated 18/7/23.
Blood, it is endorsement, Millard. As per this endorsement, Millard, I can apply. With liberty, Millard.
It's not on record. Mr. You want to withdraw, you can do so.
Millard, I will file, Millard, brought on record, Millard, this.
Don't do this thing. 5 minutes is gone in this process.
Yes.
We thought an innocuous thing, but nothing is innocuous in these matters, right? Everything we have to be extremely cautious.
After filing the petition,
92
they have
acres of land you are claiming.
After filing the petition, they have issued.
Learned counsel for the petitioner prays for adjournment to enable him to place on record copy of endorsement dated 16/6/23 and 28/7/22 endorsements dated so and so 26/6/23 and 18/7/2023 issued by collector Medchal Malkajgiri district. List after 2 weeks. The application filed by the HMDA comes 3 months, 4 months, 5 months. These applications not filed. 1 day back, not after that served upon me, I request yours. Who has served counter?
Counter, we have filed the counter.
We means who, Mr.
Respondent.
All respondents.
Yes.
You will file a reply. Learned counsel for the learned counsel for applicants. Applicants submit that the respondents that he has been served with a copy of the counter filed on behalf of respondents yesterday only. He prays for and is granted 2 weeks time to enable him to file a reply spoke rejoinder to the counter. 3 weeks. List thereafter 163 to 165.
The lordship, for the petition, we have received it.
I'm appearing for first response. I filed the not counter.
Today, learned counsel for respondent number 1 submits that he has filed the counter today, a copy of which has been supplied to learned counsel for the petitioner. Paragraph in view of aforesaid, no applicant. In view of aforesaid, learned counsel for the applicant. Grace fund is granted 3 weeks time to enable him to go through the same and to file a reply stroke rejoinder to the counter filed on behalf of respondent number 1 list after 3 weeks.
At 167 and 168 go together, Milord. The largest may kindly take up item 168, Milord. WP3.
No, what happens to 167?
Milord, both are.
You are not well. How are you now? Okay. Last date you were not
Yes,
well.
yes.
What is the petition?
Milord, 34979 of 2022, Milord. These.
No, first one, 13141. Then we go to next case. What is the prayer?
Milord, the petitioners, Milord, they have purchased, Milord, small plots from defendant number 206, Milord, by way of registered sale deeds. Thereafter, Milord, they have submitted, Milord, application for grant of construction permission to the GHMC. Milord, GHMC, Milord, rejected, Milord, the case of the petitioner, saying that it is recorded as government land. So,
So it is not covered. No. So we have got it. Your case is that your plot is not covered by civil suit 14 of 15.
No.
And it is not this thing in the prohibitory list of properties.
It is not that. Page 23.
That's the case, right?
Milord, the petitioners, Milord, purchased the plots.
No, that he wants registration of sale deed.
Now.
So we will defer consideration on your writ petition.
Milord.
As the report of commissioner is awaited, right?
Now, Milord, in where.
No. What will happen is that your sale deed is registered.
Yes.
Then you will sell it immediately next day to other person. Then he will also come to the court that my sale deed, I want to sell the property, my sale deed is not being registered.
I am not selling, Milord. Milord, I have to execute mortgage deed in favor of GHMC. Milord, construction permission was granted, Milord, in pursuance to the orders of this honorable court, Milord, page 23.
No, we would like to defer Mr. CS, the report of this thing commissioner in CS 14 of 1958. Correct?
Yes, ma'am.
You know it, let the report come.
Milord, because, Milord, already, Milord, the permission was granted. Milord, it is, Milord, subject to result of the petition. Milord, this honorable court, Milord, already granted, Milord, direction. Milord, in respect of, Milord. report. In respect of very same survey number, my lord, apartments were
Is this land is a part and parcel of the preliminary decree?
yes, my lord.
Did you file a copy of the preliminary decree?
My lord, preliminary decree, my lord, entirely, my lord, final decree was passed, final decree was confirmed by this honorable court. My lord, thereafter purchasers were, my lord.
Is Hafizpet village is forming part and parcel of that preliminary decree?
Yes, my lord, item 37. Item, all those things, my lord, were dealt with, my lord, by this honorable court, my lord, page 23. What happened, my lord, after purchase by way of registered sale deed from the final decree holders, the petitioners, my lord, submitted application for JHMC, my lord, for construction. That was rejected. That was fallen for consideration before this honorable court, my lord, page 23. My lord, this honorable court directed, my lord, after dealing with all the, my lord, area orders, my lord, para 35, my lord, your lordships may kindly see. The table was given, my lord, how many times government went to Supreme Court, how many, my lord, orders were passed against the government. All those, my lord, all those orders were extracted. My lord, after that, my lord, para 40. Para 39. Para 35, my lord, the table, my lord, how many times went to. Final decree passed in respect of this land, my lord, was upheld by the division bench of this
No,
honorable.
this is 78.
Sir,
Your survey is 78.
Survey number 78.
Your land is
now,
also.
Now the issue is, my lord, my lord, this order was confirmed by the Supreme Court. My lord, the collector issued notification, my lord, not to entertain any registrations. My lord, that was challenged, my lord, page 19. Because of that, my lord, the mortgage deed, my lord, which has to be, my lord, executed in favor of JHMC was not registered. That is the grievance of the petitioner. My lord, petitioners, my lord, have paid, my lord, the stamp, my lord, conversion charges, all things, my lord, to the JHMC. Page 39, para 40, I may be permitted to read, my lord. Page 39, para 40, 41, my lord, I may.
Go to page 41.
My lord.
The finding is that only it is to the extent of the shortfalls.
Yes.
Survey number 78 of Hafizpet village,
Yes.
part and parcel of CS 14.
Yes.
We have to await for the report, call for the objection,
My lord,
then pass final orders.
my lord, in respect of this property, my lord, already report was filed way back in the year 1984. My lord, report was accepted, final decrees were passed. My lord, the government challenged those final decrees. My lord, when final decree is passed, my lord, suit terminates insofar as that property is concerned. My lord, the report nothing to do, my lord, insofar as CS 14 is concerned. Only one property, my lord, is receiver has to file report. All other properties, my lord, reports were filed, final decrees were passed.
Reports at this stage, we are not going to examine. Only the report which would be filed by the new set of receivers will be considered.
My lord, in view of the, my lord, orders of this honorable court, my lord, WP 24115 of 22, my lord, by the.
That's recently, my lords, honorable Supreme Court, my lords, dealing with CS 14, my lords, passed elaborate order, my lords, and observed that.
My lord, the result of the writ petition, let the mortgage be.
That, my lords, preliminary decree, nothing than a mere paper, my lords. It's a fraud played on the court, my lords. May I read the relevant paragraphs of the honorable Supreme Court judgment, my lords, with your lordship's permission, my lords.
That is relating to, my lord, survey number.
And more, my lords.
Relating to.
You must instantly reply, sir, instead of waiting for your reply.
Yes.
Moreover, only smile at us. That's all. Don't say anything. And say only thing is CS 14 of 58. That's what you would.
Recently, my lord, the special division bench also directed the revenue authorities not to entertain any mutations or registration with regard to the subject property pertains to CS 14, my lords. May I circulate the copy of the order, my lords, with your lord permission, my lords. In dealing with the contempt case, my lords.
But already orders were passed, my lord, by this honorable court, my lord, subject to result of the writ petition, registrations can be entertained. Petitioner
This is part of the preliminary decree passed in civil suit 14 of 1958.
Petitioner is
You are not
going to sell
disputing
away.
this.
Blood petitioner is not going to sell away the property.
No, we don't
Blood,
know.
he is, my lord, he want to execute the mortgage deed in favor of JHMC for starting construction. That is the grievance of the petition. Let the mortgage deed can be registered subject to result of the writ petition. Blood, as already.
Ready to take the mortgage. You have to say that.
My lords.
GHMC now at this point of time is ready to take the mortgage.
Because of subsequent developments, my lords have wished to appoint a
petition,
set of civil commissioners, my lords. We are not entertaining any sort of mortgage or sale deeds pertaining to CS 14 matters, my lords.
Subject to the writ petition, my lord, it can be registered, my lord. I will abide by the orders of writ petition. But if entire property goes, my lord, I will also.
You will execute a gift deed along with construction. Supposing if they don't like it, then
Blood. That they are regularizing, my lord, all the properties, my lord. Already, my lord, this honorable court, my lord, passed orders.
GHMC. You're also representing GHMC, right?
I need to get instructions, my lords, in this case, my lords. I'm not.
Who represents GHMC? We have a council, right? No, not a party, Mr.
JHMC, my lord, because of the letter issued by the district collector, my lord, they are not registering.
This is GHMC is a proper party. You implead GHMC also.
JHMC, I will implement.
After arguing the matter some extent, learned counsel for the petitioner praise warrant is granted 2 weeks. There are 2 weeks time. 2 weeks.
2 weeks.
169. Yes.
This is in respect of
Huh?
determination of a legal heir.
Lord,
It has to be done under Order 22, Rule 5, Millard. Based on the earlier in some writ petitions, the gentleman was imputed as a legal representative. The trial court passes an order now saying that he is a legal heir. Lord, my lords are aware. Lord, Order 22, Rule 5.
No. Who died and whose LR was sorted?
Lord, defendant number 58. Lord, he is claiming to be the legal heir of defendant number 58 in CS 14.
Defendant number 58 died when?
Long back, my lord, actually.
And who was substituted as
in 2021, my lord. In 2021, she died. And after that, my lord, the another glaring aspect of it is, your lord would kindly, Lord, see, my lord, page 23.
2021.
Yes.
365 days a year, whatever, somewhere in one of those 365 days, according to you, defendant number 58 died. We are unable to find out the date of death of defendant number 58. Then when this application was made, by whom?
We are opposing an order passed by the trial court impleading somebody whose identity is not established to be a legal heir of defendant number 58.
We understood. It's not that difficult, mister. And you are trying to tell us, we will tell you the next what you have not told, that in case there is a dispute with regard to legal status of a person as LR, Order 22, Rule 5.
Yes. I
You
would
tell
just
us.
like
Yes, my
by your
lordship.
lordship.
Which
standard.
respondent?
There is already.
Respondent number one, my lordship. Beg to represent this case party in person, my lordship,
No,
for
no.
your.
14%.
Yes, my lordship, because I have to represent party.
Then go outside.
Yes,
This is not your, don't do it here. Go outside. This is not your dressing room.
There is already an industry dispute between the parties where.
No, Mr. We fail to understand a simple question to you. You are telling us the facts, right? That defendant number 58 in the suit died in the year 1958.
2021.
2021, right? Then who filed an application for his or her or its substitution as a LAP? Which respondent?
Well, respondent number 2.
That's what we are asking.
CRB
So
has
you are
filed. Respondent number 2 in the CRB has filed the LR application before the trial court.
You will not tell us, we will have to study. We thought that you are here to assist us. That's why we were asking questions, but it's better to read. So D2 had, R2 had filed an application for substitution. Exhibit table application. No disputed petitioner disputed by filing a reply. Petitioner in this petition filed and without inquiry. See, this CRP is filed by respondent number 1 in the IA 331 of 2022.
Yes.
The company, how can they dispute the status of the parties?
But your lordship would kindly have a glance at page 23, Millard. There is already an issue amongst the parties with regard to who is the legal heir, and the trial court has issued a public notification. That is at page 23, Millard.
It's misleading, my lordship. Trial court did not issue that public notification. By the parties.
Wait.
It's my lordship.
That's why the rules for this thing prohibit that rather it is recommended that party in person should not appear. You just carried away as if that whatever he says is gospel truth and petition will be allowed without hearing. Like just like behaving like this thing.
My apologies, my lordship. My apologies.
Let him.
My apologies.
You want any assistance? We will appoint some amicus for you.
No, lordship. I'll argue this matter.
Then behave like
my lordship. My apologies.
Millard, there is already a suit that your lordship would find at page
20. You are a defendant in that OS. This. Yes, appeal suit. In appeal suit, the application is allowed. Said that in a suit, defendant number 50 that in appeal, defendant respondent 58. In just a minute. See, they don't even Great way of assisting the court, Mr. We really compliment you for the manner in
No,
which
Millard,
you are arguing.
I'm sorry, Millard. Actually, I was in an argument in another court. I could not come out of that.
Then you
sorry,
should have
Millard.
sought an
Extremely
adjournment.
sorry. It won't happen once again, Millard. Actually, there was some confusion. Well, I'll clarify, please. I do admit my mistake. In fact, I was into some other case and suddenly I rushed here. So in the process, I was still established.
You want time to
Yes,
argue?
next week, Millard, I'll ask.
Learned counsel for the petitioner again praise for adjournment.
Done.
No, no. Say this in the beginning if you want an adjournment, not after party has appeared in person.
Last time, it appears your lordships were not inclined to grant an adjournment and I was held up elsewhere. So I thought I should not again.
No, no, it's your CRP. No, no, your CRP. If we need not say any further.
My lord, I am beholden to your lordship.
This all prosecute it at your own leisure.
Your
What is the
lordship
hurry?
magnanimity, my lord, I appreciate.
You are an officer of the court assisting us in speedy disposal of the case by seeking adjournment twice. That's what we can say.
We
Thank
need
you.
to confess our
Next.
mistakes also.
Mr.
My lords, this is a covered matter, my lord. This is for the registration, not allowing the sub-register. I mean, actually, tower 20, 14th floor, second hand flat, I'm selling my plot, my lord. All the other neighbors got the allowed for the registration. They're stopping me, my lord. They're violating larger constitutional
Have you?
Case, my lords, petitions.
1 minute.
Yes.
Last order, do you know or you don't know?
Yes, I am aware, my lords. Petitions relying on the judgment dated to.
No, no, no. So direction issued by learned single judge have been implemented?
Yes, my lords.
Then
it was implemented, my lords.
So how can you say that?
In this case, my lords, particularly petitioners want to create third party interest, my lords. In those cases, my lords, owner approached this honorable court by way of owner or landlord or developer approached this honorable court, my lords. But in this case, my lords, a sale deed was executed in favor of the petitioner on 19/12/2019, my lords. And now that, my lords, petitioners want to create third party by alienating to third parties, my lords. That is specifically prohibited by the division bench of this honorable court and the learned single judge also, my lords. Not to alienate further. There is specific rider in that order, my lords. And subject property is not subjected to further alienation, my lords.
Survey number 78.
Yes, my lord.
78, my lords.
So this is his case also 78. Of his fate. He is also claiming the title in respect of 92 acres of land, right?
No, my lord. Mine is a plot, my lord. In the 14th floor.
Last line, my lords. Last line of the.
Just a minute. Where is the order passed by the, you were saying that there is an order of stay not to register in, there is a direction to not to register any sale deed in respect of property survey number 78.
Not only survey number 78 minutes pertains to all CS 14 matters, including while contempt.
No, where is that order?
And circulating.
Give. See, Mr. If there is a subsisting order by this court, your remedy lies in seeking vacation of that order. If it is so, we don't know. He's searching.
May I circulate the copy of the order?
Got it?
While closing a.
Yeah, I have copy page number 19, my lords. After
There is an order of stay.
that is a proceeding of the collector, my lord. The covered matter is page number 25 to 48.
Not covered. Mr. What you understood what he said? No. He's saying that there is an order of stay grant direction issued by this court in something what we don't know.
Contempt case.
So, directing the authorities not to register any deed in respect of land bearing survey number 78 at Hafiz Pet village.
Not only 78 matters pertains to CS 14. All the matters pertain to CS 14.
Where is the order? Give him a copy.
While closing the contempt case, not only in this contempt case, in several other matters also, my lords.
No, you cannot make an omnibus sort of a statement and we don't know which other case. We are taking up this item.
Talk about page number 5, my lords. Page number 5, para number 10, my lords.
Give him a copy.
Yes.
My lord, this is in a 2017, my lord. The covered matter already division bench issued a 2020 order, my lord, to allow the registration. This is a 17 case, my lord.
They read
Where is the direction?
para number 10, my lords. We may mention that page number para 10, my lords. we may mention that CS 14 of 1958 is still pending for final closure. We have a
Mr. You must appreciate, I mean, it's really a pity that saying that a division bench of this court has issued prohibitory orders and saying that no direction can be issued in the facts of that case, different thing. Saying that in view of order passed by division bench, petitioner is not entitled to any relief is different than saying that the court has prevented us from registering the document. That statement is not there in this order.
I'm not saying that, Manas.
You said this. This is what you heard, right?
Yes, my lord.
We also heard understood same way.
I want
Brother
to
has
place-
understood
Manas,
the
I
same
want to
way.
place
You are
other-
saying not the.
I want to place the other copy of the order, Manas, passed in WP number 25294 of 2022.
No,
Manas.
what about this? What about making false statement before the court?
I'm not making.
You said that court has prohibited us from registering document in respect of property number 70, this survey number
May
74.
I communicate the copy of the order, Manas?
You read it first.
Yes, Manas.
Otherwise, we will haul you up.
Yes, Manas.
You have
Manas, in this
this
case,
thing.
in this case,
In
Manas,
there is no order in this writ appeal.
in this case, Manas, particularly petitioner relying on WP number 25294 of 2022, Manas, on last occasion, Manas, petitioner circulated the copy of this order to the Honorable Court, Manas. May I read the last paragraph, Manas? However, it is made clear that the registration of the document shall be subject to final result of the writ petition. The registration is a provisional one, and mere registration of document does not confer title to the petitioner in respect of the subject property. It is made clear that the petitioner shall not claim any equities in case any adverse orders are passed against the petitioner.
I am aware by the conditions, my lord.
It is also made clear that the registering authority would be entitled to make an endorsement about pendency of the present case and shall ensure that the subject property is not subjected to further alienation. In this case, my lords, particularly petitioner want to create third party interest, my lords. Already sale it was executed in favor of the petitioner way back in the year 2019, my lords.
No. That doesn't, he is entitled to register the document on the strength of the order you are relying upon.
My lords, in this case, my lords, particularly
This supports the case of the petitioner
not
rather
to
than
create third party interest, not to further alienation, my lords. That was the purport of the order. my lords.
grievances with regard to registration.
Yes, my lords.
It has been granted, the order you are reading.
In those cases, my lords, landlord approached this honorable court, my lords, and the developer has approached this honorable court, my lords, not individuals, my lords. With great respect, my lords.
No, how does it make a difference so far as registration of a document is concerned? Document, according to, we are putting you a query, document has to be registered if the conditions mentioned in the statutory provision are complied with. Right? I don't know what is the provision in our this thing act I have come across, it was 25O, where these conditions are mentioned. If these conditions are fulfilled, registering officer shall conduct an inquiry and then register a document if necessary, otherwise on fulfillment of those conditions. So where is the order that he cannot transfer?
May I communicate another
No, is petitioner a party to that order?
No, my lords.
That
Last occasion, my lords, petitioner relied on this order, my lords. That's why, my lords, I am bringing same survey number, my lords, 78. That's why, my lords.
that order, Mr. You read it again. It appears to be in favor of the petitioner. Please read it. It says that the document shall be registered. The registering authority will be entitled to make an endorsement in this thing.
Yes.
That the dispute is subject matter and all that.
There is a further rider to the defect, my lords, not to create further alienation, my lords. Petitioner want to create third party interest, my lords. That's what I want to distinguish with the present case and
Where is 25294, Mr. Which page?
My lord,
Have you filed this order? WP 25294 of 2022.
other day, my lords, petition circulated to the bench, my lords.
That's the problem, right?
covered matter, my lord, covered matter, division bench, 25 to 48.
Where is the order on which you are saying that it is covered? Which order? You
Like
have filed
24348 of 2020, my lord.
348.
Yes, my lord.
That is regarding what?
Regarding what to, like, it's to allow the registrations, my lord. In the page number 48 in the page number 48, my lord, in my affidavit.
This property in this case was sold under SURFACE Act.
Well, this
So
subject.
court, wait,
Sorry. Extremely sorry.
you cannot dictate an order.
Sorry, I'm extremely sorry.
This property, this dispute in this case pertains to registration of a sale certificate under section 13 of, in respect of a major and taken under section 13, sale certificate issued. In that context, it is said 4 weeks. And where is this survey number 54 and this Hafiz Pet village in this case? There may be hundreds of cases where there are directions to register the sale deed. All you cannot say that covered.
78 survey number, my lord. It is for 78.
So then if it's 78 survey, subject matter of civil suit, it has to be before a division bench. Correct? It has to be before a division bench.
My lord, based on his judgment also, they cannot stop my registration. It's January 23rd of 2023 judgment, my lord.
No, last date of
January 2023.
Last date of hearing you relied on 25294. Today you have changed the number to 24348. So please clarify which order you are relying. In case 25294, then you have to produce that order. Or we will have to record that now you are relying on 24348.
State government preferred SLP minutes against order dated 4/2/2021 minutes. It is pending for adjudication minutes.
Again, which?
Petition number 24348 of 2020 minutes. May I circulate the copy of the order minutes?
Then it don't the burden us with unnecessary orders. We are asking about 25294.
Yes.
Don't, may I circulate, then we have to read.
Now that minutes.
This is, Mr. All of you see what is the level of assistance being provided to us.
Now that minutes petitioners are relying on 24348 of 2020 minutes.
No, in the last date of hearing, they relied on 25294. Where is that order?
I have the copy of that order minutes.
So against that order, you filed SLP?
No.
Then,
they are not prepared any SLP.
Then we asked you whether that order has been implemented.
Yes, madam, implemented minutes.
That,
I got
so you are not implementing it on the ground that he wants to transfer. He doesn't want. He wants registration of the document in his favor.
Not in his favor minutes, to the third party minutes, if I am not.
Third party?
My lords, page number 47.
Already sale it was executed in the year.
Yeah, registration, because I'm selling my property, my lord, because of my parents' treatment for the Kerala.
And your contention is that he cannot be permitted to, the registering officer will not permit the registration because he will not register the document because he is selling the property.
Creating third party interest, but that's what I want to take. Already sale deed was executed in his favor minutes, 19/12/2019 minutes.
This is single bench. This is an order passed by single bench, Mr. Interim order. This is not a precedent.
Division bench.
No,
Which order?
you don't understand anything, Mr.
My lord,
Unfortunate. Learned counsel for the petitioner is
lord, one
directed.
submission.
Just a minute.
One submission.
No. The learned counsel for the petitioner is directed to place on record copy of order dated 13 day of September 2000. An interim order passed by a learned single judge. Interim order cannot never be cited as a precedent. Please tell him. Parallel communication is very fast. No. This sort of this thing is very difficult. Horizontal, this thing, parallel communication is very easy because they perceive us as enemy. So they think that whatever we speak is always against them. He is relying on an order passed by learned interim order.
In these matters, in the Supreme Court, I only appear.
Interim order passed by learned single judge before division bench and saying covered. Please, Mr. Make use of this weekend for studying Article 141, what is ratio, what is interim order is a binding precedent or a precedent for that matter, leave alone binding. Then interim order passed by a learned single judge binds the division bench. Then tell us.
This is also identical to the 170 minutes.
This you could not tell, right?
In this matter also.
This you could not tell that this is an interim order on which he is placing reliance.
Interim order basing on the division bench orders, my lords, those interim orders were passed, my lords.
This is what we told you, did not say this. You also don't know that interim order is not a precedent, right? So therefore, you should along with him study Article 141, right? You should have said, sir, this is an interim order by a learned single judge. It is not a precedent.
You should have a refresher course for the lawyers also.
Yes, Mr. 171. Call Madam 171. He is appearing. None for petitioner. Hearing is deferred. List after 4 weeks.
My lord, in item number 172 to 185 I appear, my lord, except for item number 177 in which I am petitioner, I wear the respondents hat in all the other matters.
You are for respondents.
I am for the respondents, all the matters except 177 by law, for which I am for the petitioner. Item number 177 is a petition for a final degree. Is a petition for a final degree. Now, my lord, as your lordship is deferring all matters for final degrees, awaiting the report of the new report of the advocate commissioner, this may be deferred, my lord. The other matters in which I appear as respondent may be posted after 2 weeks.
Particularly,
This supports the case of the petitioner
not
rather
to
than
create third party interest, not to further alienation matters. That was the purport of the order.
grievances with regard to registration.
Yes, matters.
It has been granted the order you are reading.
In those cases, matters, landlord approved this honorable court matters, and developer has approved this honorable court matters, not individuals matters. With great respect, matters.
No, how does it make a difference so far as registration of a document is concerned? Document, according to we are putting you a query, document has to be registered if the conditions mentioned in the statutory provision are complied with. Right? I don't know what is the provision in our this thing act I have come across, it was 25O, where these conditions are mentioned. If these conditions are fulfilled, registering officer shall conduct an inquiry and then register a document if necessary, otherwise on fulfillment of those conditions. So where is the order that he cannot transfer?
May I communicate another
No, is petitioner a party to that order?
No, matters.
That
last occasion, matters, petitioner relied on this order, matters. That's why, matters, I am bringing same survey number, matters, 78. That's why.
That order, Mr. You read it again. It appears to be in favor of the petitioner. Please read it. It says that the document shall be registered. The registering authority will be entitled to make an endorsement in the this thing.
Yes.
That the dispute is subject matter and all that.
There is a further right of matters to the defect matter not to create further alienation matters. Petitioner want to create third party interest matters. That's what I want to distinguish with the present case. And
where is 25294, Mr. Which page?
My lord,
have you filed this order? WP 25294 of 2022.
Other day, petition circulated to the bench matters.
That's the problem,
Covered
right?
matter, my lord. Covered matter. Division which 25 to 48.
Where is the order on which you are saying that it is covered? Which order? You have filed
24348 of 2020, my lord.
348.
Yes, my lord.
That is regarding what?
regarding what to, like, it's to allow the registrations, my lord, in the page number 48 in the. Page number 48, my lord, in my affidavit.
This property in this case was sold under SURFACE Act.
Well, this
So
subject.
court, wait,
Sorry. Extremely sorry.
you cannot dictate an order.
Sorry, I'm extremely sorry.
This property, this dispute in this case pertains to registration of a sale certificate under section 13 of, in respect of a measure and taken under section 13, sale certificate issued. In that context, it is said 4 weeks. And where is this survey number 54 and this Hafiz Pet village in this case? There may be hundreds of cases where there are directions to register the sale deed. All you cannot say that covered.
78 survey number, my lord. It is for 78.
So then if it's 78 survey, subject matter of civil suit, it has to be before a division bench, correct? It has to be before a division bench.
My lords, based on his judgment also, they cannot stop my registration. It's January 23rd of 2023 judgment, my lord.
No, last date of
January 2023.
Last date of hearing you relied on 25294. Today you have changed the number to 24348. So please clarify which order you are relying. In case 25294, then you have to produce that order. Or we will have to record that now you are relying on 24348.
State government preferred SLP minutes against the order dated 4/2/2021 minutes. It is pending for adjudication minutes.
Against which?
Petition number 24348 of 2020 minutes. May I circulate the copy of the order minutes?
Then don't the burden us with unnecessary orders. We are asking about 25294.
Yes.
Don't, may I circulate, then we have to read.
Now that minutes.
This is, Mr. All of you see what is the level of assistance being provided to us.
Now that minutes petitioners are relying on 24348 of 2020 minutes.
No, in the last date of hearing, they relied on 25294. Where is that order?
I have the copy of that order minutes.
So against that order, you filed SLP?
No.
Then,
they are not prepared any SLP.
Then we asked you whether that order has been implemented.
Yes, madam, implemented minutes.
That,
I got
so
it,
you are not implementing it on the ground that he wants to transfer. He doesn't want. He wants registration of the document in his favor.
Not in his favor minutes, to the third party minutes, if I am not.
Third party?
My lords, page number 47.
Already sale it was executed in the year.
Yeah, registration, because I'm selling my property, my lord, because of my parents' treatment for the Kerala.
And your contention is that he cannot be permitted to, the registering officer will not permit the registration because he will not register the document because he is selling the property.
Creating third party interest, madam, that's what I want to take. Already sale deed was executed in his favor minutes, 19/12/2019 minutes.
This is single bench. This is an order passed by single bench, Mr. Interim order. This is not a precedent.
Division bench.
No,
Which order?
you don't understand anything, Mr.
My lord,
Unfortunate. Learned counsel for the petitioner
my
is
lord,
directed.
insufficient.
Just a minute.
Insufficient.
No. The learned counsel for the petitioner is directed to place on record copy of order dated 13 day of September 2000. An interim order passed by a learned single judge. Interim order cannot never be cited as a precedent. Please tell him. Parallel communication is very fast. No. This sort of this thing is very difficult. Horizontal, this thing, parallel communication is very easy because they perceive us as enemy. So they think that whatever we'll speak is always against them. He is relying on an order passed by learned interim order.
In these matters in the Supreme Court, I only appear.
Interim order passed by learned single judge before division bench and saying covered. Please, Mr. Make use of this weekend for studying Article 141. What is ratio? What is interim order is a binding precedent or a precedent for that matter, leave alone binding. Then interim order passed by learned single judge binds the division bench. Then tell us.
This is also identical to the 170 minutes.
This you could not tell, right?
In this matter also.
This you could not tell that this is an interim order on which he is placing reliance.
Interim order basing on the division bench orders, my lords, those interim orders were passed, my lords.
This is what we told you. Did not say this. You also don't know that interim order is not a precedent, right? So therefore, you should, along with him, study Article 141, right? You should have said, sir, this is an interim order by a learned single judge. It is not a precedent.
You should have a refresher course for the lawyers also, brother.
Yes, Mr. 171. Call Madam 171. He is appearing. None for petitioner. Hearing is deferred. List after 4 weeks.
My lord, in item number 172 to 185, I appear, my lord, except for item number 177, in which I am petitioner, I wear the respondent's hat in all the other matters.
You are for respondents.
I am for the respondents in all the matters except 177, my lord, for which I am for the petitioner. Item number 177 is a petition for a final degree. Is a petition for a final degree. Now, my lord, as your lordship is deferring all matters for final degrees, awaiting the report of the new report of the advocate commissioner, this may be deferred, my lord. The other matters in which I appear as respondent may be posted after 2 weeks. I appear for the respondents in his final degree petition.
So correct, right? Item 177 marked their presence. A report by the receiver cum commissioner of the commissioner appointed by
No.
yes. Yes, madam. Report of the commissioner cum receiver is awaited. Awaiting report. Hearing is deferred. Hearing is deferred by 4 weeks. 187. Yes, 187.
Along with 177. Connected.
187.
77.
Acha. List along with item number 177. Item 177 means you write case number, right? Ah, all right. Then
Milord, in item number 188, I appear for the respondent, writ petitioner. This is the writ appeal, milord, filed by the state. And I am for the petitioner. I succeeded before the learned single judge. Milord, your lordships have briefly heard this matter last occasion, and the case is like this, milord. I have purchased the land, 24 acres and 75 cents.
1 minute. Let us.
Yes.
Your appeal.
Appeal, my lord. In this matter also, my lord, receiver is appointed. He has to submit his report, my lord. My lord, a comprehensive report is expected, my lord, to be filed as per the direction of this honorable court.
This is survey number 77.
Survey number 77.
Survey number 77.
77.
Having purchased a part of the land, I applied for mutation.
We have ready.
Mutation was
We have
granted.
heard you. We have heard you on the last date. So is it part of preliminary decree?
Yes, it is part of preliminary decree. I have got, yes. The state has accepted it, but
Hello, sir. We never.
petition granted by the state, not carried out in the Pahani Patrikas.
Ah, yes.
That is the cause of
In the
action.
revenue record. Yes.
Malos, I filed implead application. This Malos.
Ah, he told us that your presence is wholly
I'm sorry,
unnecessary.
Malos, last time, apology, Malos, my colleague.
Yeah, fine. We will hear you, of course, but it's his appeal.
My appeal, my lord. This matter, if I am at liberty to say, my lord, this matter my learned friend is fairly admitted is a part of CS 14 of his fate. Survey number 77 is a part of the lands in survey number CS 14, my lord. My lord, in respect of the same village, my lord, Supreme Court had seized this matter, if I may. If Supreme Court has seized the matter and pending adjudication before the Honorable Supreme Court, in all matters we are constrained to say.
No. So Supreme Court says that the High Court should not deal with the
Status quo.
person relating to entry into Pahani Patrika.
No, my lord, this
These means
that is true. My lord, these are larger aspects that had to be.
we are asking you, Mr.
Yes, that's
What Supreme Court says.
Supreme Court.
Sub-judice means everything is sub-judice, right?
My lord, Supreme Court said status quo. My lord.
In respect of his land.
In respect of the entire 14, CS 15 lands.
There is no such order, my lord.
Let the facts
Produce the order.
in respect of the entire lands in CS 14 of Hafiz fate. This also, yes. This also forming part of that Hafiz fate, my lord. Millet, your lordship by this time.
Place on record this so that they should have, they don't know. Learned council, whatever.
The bottom page number 6, Millet.
Let him place on record, you go through it so that what happens that these people don't see what previous case happened. Interim order passed by learned single judge being told to us that covered. You saw last case.
This order
You
is-
have a look at this.
I have an idea about